All right, this is, hang on one sec. I'm going to call the meeting of the Sentencing Guidelines Commission to order. I'm Kelly Mitchell. I'm chair of the commission, and the date is October, what is the date? 7th? God, it's been one of those weeks. It's October 7th, 2021. We have commission members participating both in person in room G3 of the Capitol and also remotely. So at this time, I'm going to ask Nate to go ahead and take the roll.
Roll call. Vice Chair Estrada.
Present.
Estrada present. Blakey.
Present.
Blakey present. Hansi.
Present.
Hansi present. Knudsen.
Present.
Knudsen present. Ladd.
Present.
Ladd present. Larkin.
Present.
Larkin present. Middlebrook.
Present.
Middlebrook present. Moore.
Present.
Moore present. Schnell.
Present.
Schnell present. Chair Mitchell.
Present.
Chair Mitchell present. Madam Chair, there are 10 members absent, 1 seat vacant.
All right, so we have a quorum. So welcome, everyone. First item is to approve the agenda for the day. So I will entertain a motion to approve the agenda. Commissioner Middlebrook, we can use, go ahead and say it.
So moved.
Commissioner Middlebrook makes that motion. Do we have a second?
Yep.
Commissioner Moore seconds. Any discussion? Hearing none. If you could please read the roll on that, Nate.
To the Middlebrook motion to approve the agenda, Estrada.
Yes.
Estrada, yes. Blakey.
Yes.
Blakey, yes. Hansi.
Yes.
Hansi, yes. Knudsen.
Vote aye.
Knudsen, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Schnell.
Yes.
Schnell, yes. Chair Mitchell.
Yes.
Chair Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
And with that, the agenda is approved unanimously. So we'll move on to item 3 on the agenda, which is approval of the draft meeting minutes. Those were sent out last week, so you all should have had an opportunity to review them. At this point, I'll take a motion to approve the minutes.
So moved.
Commissioner Schnell makes that motion. Do we have a second?
Second.
Commissioner Knudsen seconds. Any discussion? Hearing none, let's go ahead and take the roll on that.
To the Schnell motion to approve the September meeting minutes, Estrada.
Yes.
Estrada, yes. Blakey.
Yes.
Blakey, yes. Hansi.
Yes.
Hansi, yes. Knudsen.
Yes.
Knudsen, yes. Ladd.
Yes.
Ladd, yes. Larkin.
Yes.
Larkin, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Schnell.
Yes.
Schnell, yes. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 10 votes in favor, no votes opposed.
All right, with that, the minutes are approved unanimously. Okay, so item 4 on the agenda, and really the majority of our agenda today is to talk through the custody status proposals. So we're essentially dedicating the meeting today to going through them. Nate's going to help lead that discussion today. A couple of things that I just want to point out and say before we get started on the discussion. So first of all, when we last met, we had 4 proposals on the table.
Yeah.
We now have 7, and that's because we made the call just to make sure that we were covering all the bases with the ideas that the commission should consider. So all 7 of those proposals have been included today. And we're going to go through each one. And my desire today is to talk about each proposal on its own merits. So I would like us to, we're going to sort of identify what the proposal is. We're going to spend some time sort of talking about what the pros and cons are. We're going to talk to the extent that we can about the potential impact of the proposals, the rationales for each proposal. But I don't really want us to talk about the proposals against each other, because we haven't, this is the vetting of each proposal today. Today is what are the merits of each one? What are the upsides and what are the downsides if we were to choose each one of these proposals? So that's how I would really like us to focus our discussion today. My hope is that by the end of the day, we will all have a better understanding of what the options are in front of us, and we maybe even could potentially narrow it down to the things we think might be the better policy options. Maybe we could narrow it down for November. So that would be the goal. We're going to go through that discussion, but one thing that I did ask the staff to make sure that we all had a grounding in was, who's getting custody status now? And so one of the staff reports that was sent out, and Nate will have to tell you which letter it was, really just looks at who's getting custody status, where are they falling on the grid, just so we can make sure that we're all grounded in that information. What's the baseline that we're starting from? And then we'll talk about each of the proposals after that. So I don't anticipate that this first piece taking very long. And I would just ask Nate to kind of quickly walk us through the information the staff put together on that.
Thank you, Madam Chair. It's 4E, and if you give me a moment just to share my screen here. So 4E is custody status of offenders by race and grid zone. That's the staff issue paper dated September 27th. So this is the concept of a grid zone. I think I have to give credit. I think it's Professor Fraze came up with this concept. But basically the idea is under sentencing guidelines, there's really one of three reasons, at least under Minnesota's scheme, there's one of three reasons why the guidelines would presume prison for an offender. And those reasons are, one, it's a severity level. Let me just go down to the standard grid here. So on the top here, you see severity. The other option is it's criminal history. So and severity means that it wouldn't really matter what the criminal history were. This crime is considered to be so serious by the Minnesota sentencing guidelines that even a first offender should go to prison for some duration under the sentencing guidelines. The history section is a section where the crime is not considered so serious that a first offender should go to prison. But eventually, after some period of time, after some criminal history, it is appropriate that prison should be the presumptive sentence under the sentencing guidelines. So that applies to offenders with higher criminal histories. On the standard grid, you see you have to have at least a criminal history score of 3, and for severity level 1 and 2 offenses, you have to have a criminal history score of 6 or more. So that's the history section, and then the mandatory minimum section is the shaded section of the sentencing guidelines grid, and that it would presumably not be a prison sentence, but under some circumstances where the legislature has deemed it to be appropriate, where there's a mandatory minimum in statute, then it is. So that's sort of the general concept here of zones. So before we get to that, though, Figure 1 shows sort of an overview of felony cases sentenced by grid type. And you can see that most of cases are sentenced on the standard grid, 71%. The drug offender grid takes up another 22%, and only 6% of the cases are sentenced on the sex offender grid. If you just look at custody status offenders, so we're going to be spending most of the time here talking about custody status offenders. Those are people who have in their criminal history score custody status point or partial point, which means that at the time they committed the offense, they were under some sort of supervision, either for a felony, for a non-traffic gross misdemeanor or a DWI, or for a targeted misdemeanor, which is a pretty small list of misdemeanors. Of those custody status offenders, the distribution is fairly similar. We see that the drug offender grid has 4 percentage points more of the custody status offenders than the other grids, and the other grids lose 2 percentage points each to the drug offender grid, essentially. So now we're going to look at each grid and these 3 different zones and look at how it's broken down. So each of these grids is all cases, not just presumptive commits. Since the 3 zones are only talking about cases where the guidelines consider prison to be appropriate, the area that's not shown here are these presumptive stays, which are the white part of the bar, essentially, or it's nearly white. It's very pale blue, I think. So that constitutes, for most of these racial groups, constitutes well over half of the offenders. There's no prison presumed. And then you can see the distribution of most of these cases are presumed prison, not because of severity or because of a mandatory minimum, but because of criminal history. So they are the history section of the grid, which shouldn't be surprising when you consider the fact that the commission has reserved the higher criminal history scores for the very most serious crimes. So most of the felony offenses are in the lower severity levels, and so it's not surprising that among those who are presumed to be commit, history is the major reason why. Let's see. I'd like to call your attention here to a particular thing that's unique to this grid, which is this shaded area here in the history section. What this shaded area indicates is this is essentially 1 square to the right of the disposition line. So these are people who just barely made it into the history section. If they had been 1 criminal history score lower, they would not have one criminal history point lower. They would not have been in the history section. They would have been in the shaded gray. Katie, who wrote this, breaks it down here to say that 22.5% of the offenders who were in the history zone, and this is just custody status offenders. So we should keep that in mind. For the rest of this report, we're only talking about custody status offenders, meaning offenders who had, as part of their criminal history score, some sort of custody status point. So 22.5% of the offenders on the standard grid who were custody status offenders, 22.5% of those offenders had a presumptive prison disposition due to custody status. Okay, and then it also shows you the overall breakdown. It's broken down by race on that chart. So 4.7%, less than 5% are in the severity zone, over 35% are in the history zone, and 3% are in the mandatory minimum zone. And then 57% are presumptive state. And then the racial and ethnic makeup is broken down. It's just to explain how this chart works. The top row, I believe that's white, is just the raw numbers, and then the second row, the yellow row, is what percentage of the severity zone is taken up by that particular racial or ethnic group. And then the next line down, which I think is green, I'm having a hard time seeing colors on the screen, but that shows what percentage of that grid zone is taken up by that racial group. So those total 100 going vertically, and the other totals 100 going horizontally. So that's how to read table 1. Table 2, again, similar for the sex offender grid. It's In this case, 13.5% were in the severity zone. So a higher percentage for sure in the severity zone. 11.3% were in the history zone, so a much lower percentage. So we actually have more people in the severity zone than the history zone. And 66.7% were in the mandatory minimum zone. So most of these cases, and you can see most of these cases, you end up with a presumptive commit because of the mandatory minimum. And then this, and I should say again, it's a similar percentage of the offenders, of that small percent of the offenders in the history zone, a similar percentage are there because of custody status, 21.6%. And then we see the drug offender grid, which has a much higher percentage of presumptive stayed cases, almost no mandatory minimum cases. The majority of those who are presumptive commit are history, kind of like the standard grid there. And again, like the other two grids, very similar number, 22.8% of the offenders in the history zone, just those offenders in the history zone, had a presumptive prison disposition due to custody status. So that's an overview of 4E, Madam Chair. I don't know if you had anything else you wanted to point out or any questions you had.
No, there's nothing else. Thank you for going through that. Does anyone on the commission have any questions before we move on?
Madam Chair, this is Ladd, and I did have a question about that.
Commissioner Ladd.
Thank you. What I wanted to understand was on page 7 of that report, where you had it broken down into the stay of imposition, stay of execution, and in the prison, there was a chart on that. Am I reading that correctly, that 68% of the sentences were stayed versus 32% were prison commits? Is that the appropriate way to read that grid or that pie chart?
So you're looking on page 7, the very last page?
Yes.
And I'm sorry, I didn't cover that page, Madam Chair, but that's right. I can share my screen again. All right, so that's correct. So this is looking at all people who received a sentence who had a custody status point. So all custody status offenders, of those, only 32% received a prison commit. And of those who did not receive a prison commit, 45% received a stay of execution. I'm sorry, of the whole 100%, 45% received a stay of execution and 23% received a stay of imposition. So about 2/3 of the pronounced sentences for these custody status offenders were stays of execution.
Commissioner Ladd, do you have a follow-up, or does that answer it for you?
No, I just wanted to clarify if I was reading that grid right, that essentially 32% of custody status offenders got prison sentences. The rest of them were a stayed sentence. Thank you.
Right, and that's consistent with sort of the overall pattern that we have in sentencing generally from year to year.
And I think I misspoke there. I said 2/3 of those who received a stayed sentence, 2/3 received a stay of execution, not 2/3 of all custody status offenders.
Right. Oh, yeah, that's right. You're right. That's correct. Okay, any other questions on this? Okay, hearing none, let's move on to the main event, which is discussion of the proposals. So, Nate and I talked ahead of time about, what's a good way to organize it. We have information that's sort of spread across the different handouts, but we want to keep the discussion about each topic, about each proposal by proposal. So, so we are going to kind of be looking across handouts the whole meeting. So I'm sorry if that's a little confusing, but the idea would be like, let's talk about what the proposal is. Let's introduce some information about that proposal, and then let's open it up for discussion about the proposal. And we'll just do that for each one kind of in order. So I'm going to turn it over.
Madam Chair, could I beg your indulgence just to say a
Sure.
few words about 4B?
Yes.
Okay,
Please
thank
go
you.
ahead.
So first of all, I'd like to apologize to the commission and to the public for getting 4B out so late. We just got it out this morning, and it's really not even complete as of right now. We basically got it done in as much as complete as we possibly could. We thought even in its I guess I would say near final draft form, it would still be useful to the commission. You'll note that I think it's there's a table in there that's still blank. We just didn't have time to finish it. And there's actually a methodology question that we had that's detailed in footnote 3 about whether we were actually using the correct methodology on A1. So, and I'll talk about that in detail, but I just want to, when we talk about A1, but I just wanted to say that the, so basically, well, I not to make a ton of excuses here, Madam Chair, but we are short-staffed. And I think we realized, well, our senior research analysis specialist who's working on it realized that it would really be inaccurate to use 2019 as the baseline for, so I mean, basically impact is a change from the baseline, it's change from the status quo. And we had been using 2019 sentencing data, which is our most recent complete year of sentencing data, as the baseline. The problem with that is it really ignores the changes to sentencing policy that the commission made in 2019. The status quo isn't really 2019 sentencing practices, it's 2019 sentencing practices as modified by the commission in 2019. So we had to make some changes there. And to do that required a whole lot of work, basically looking up to be sound. It was decided to look up 25% of all the cases that were sentenced in 2019 to see what the custody status came from. Before that really wasn't that much of an issue. It didn't matter where you got the custody status from, as long as it was qualifying, it counted as a point. Well, that wasn't true after 2019. So we had to look up all of those cases, which took a long time. The other thing I'd like to say about that is we made a controversial choice. We had to choose something to be the status quo, and we made a controversial choice, and that choice was we used what I call in there the EWS method of figuring out what the status quo was for dealing with the half points. So as we all know, and as we've discussed ad nauseum, there is a problem with the half points, and really the policy is not clearly defined at this point. And that's one of the reasons we're doing this, is to define the custody status policy. But you know, so we had three choices. We could just pretend like the commission hadn't done anything in 2019 with respect to half points. That didn't seem correct. I guess four choices. One is we could just ignore half points and assume that after 2019 there was no impact to half points. We could give half points essentially a full weight in criminal history, which I guess that would be the same as ignoring what the commission did in 2019. Or we could do what we did, which is sort of a median approach, which is to use the EWS method, which is to essentially round down the unrounded sum of criminal history, which we recognize that has not been adopted by the commission. We're not trying to say that it has, but we just thought it was a middle ground approach of how to describe what the status quo is. So there's more detail. I'd be happy to talk about this. I don't want to like derail the conversation with this conversation. I just feel like it's important to disclose that. So we can move on from here, Madam Chair.
Yeah, well, thank you for that. I mean, I One thing I do want to say is that I do appreciate that the staff is always really working hard to get us the most accurate information that you can, or the best estimation that you can of the impacts of all of these offenses. So, you and I talked in between, and you told me about the issues that we were having with methodology, and I agreed with the changes that you made, and I thought it was a good decision to move forward with that. And it was going to reduce the impact of all of the potential proposals too, because, the concern that you had was that by using sort of the pre-2019 change, you were overstating the impact of any potential changes that might come out of any of these proposals being added on. So sort of recognizing the half-point world did exist, recognizing that, there were situations in 2019 that no longer merited custody status. And some of those are, the probation term that had been discharged before the end of the full probation term, that was a policy change. The stay of adjudication, that was a policy change. So there were real situations that no longer resulted in custody status, and they hadn't been accounted for before. So I think it was a good call, and I appreciate the work that the staff has done to try to get this done in the time that we can. I think that, while they probably want to go back and look at the numbers again, it at least gives us, I think, relative proportions. So which proposal is going to have the greatest impact, which proposals are going to be in the middle, and which ones are going to have the least impact. So I think we at least have that relative sense from the document you put together of
Right.
those potential impacts.
Thank you, Madam Chair. And to that, assuming, as I do, that we will be continuing this and possibly finalizing this discussion at our next meeting in November, I do anticipate having a final version of the impact statement.
Right.
So I can now do what you had asked me to do earlier, which is to go through each proposal, sort of not document by document, but proposal by proposal is what I understand you're looking
Right.
for from me, Madam Chair.
Right.
So I'm going to, again, attempt to share my screen. All right, so the first document is 4A, and so we organized these proposals. These are not in the same order that you saw them last month, so that can be confusing. I apologize for that. I was trying to organize them in a way that was a little more rational. Not that there was anything irrational about how they were organized last month, but just because there were 7 proposals, I thought it'd be better to sort of group them conceptually, so that there's the A proposals and the B proposals. The A proposals are those proposals that still retain custody status and criminal history, but they do something about it. They change it in some way. The B proposals are those that really start with getting rid of custody status and criminal history. And then B1 is, that's it. It gets rid of custody status and criminal history. And then B2, 3, and 4 do something else instead with custody status. So that's the lay of the land here. That's why you'll find that the numbers are different from how they were last month. And I apologize if that's confusing. So A1, we did see this last month. It's applying custody status only to high criminal history scores. So this is looking at the criminal history score as being the critical gateway to getting a custody status point. And it's simplified because we're getting rid of the half point here, and we're giving the full custody status point, regardless of what the custody status was from. So say it's a targeted misdemeanor, you still get a custody status, a full custody status point, but provided that your criminal history score is 3 or more. Now, that's only true of the standard grid and the drug offender grid. For the sex offender grid, that there is no 3-point requirement. So even a first-time offender, well, I guess you wouldn't be a first-time offender technically, but you still could have a criminal history score of 0. But even an offender with a criminal history score of 0 who has a custody status at the time of the offense will get a full custody status point under this proposal. There's the 2-point rule is really the same as the current 2-point rule. If both the current offense and the custody offense are sex offenses ranked at severity level H or greater, then you get 2 custody status points instead of 1. Otherwise, it's just 1 custody status point. So So this really solves the half point problem by getting rid of the half point, only having full points, but only awarding those points to more experienced offenders. And this also abolishes custody status waiver. So that was a policy that was adopted in 2019, and that's gone after A1. Looking at 4B, the impact. This is where we had, so we're jumping right into an error. So we have here a 221 bed reduction is estimated, but really, we explain why we used a different baseline for this, but I just don't think that's a sound reason. We explain why on page 2 of this document, but I really don't think it's a good reason. So bringing your attention to footnote 3, if I had another day to work on this document, you would not be seeing an impact of 221 beds. Instead, you would be seeing an impact of 42 beds. And that would be if we compared it, as we did compare all other 6 proposals, if we compared it to the adjusted baseline. And by adjusted baseline, I mean, we take the 2019 data, but then we sort of convert those sentences to sentences as they would have been under the new policy that wasn't in effect yet for almost all cases sentenced in 2019. If we use the adjusted baseline like we did for the other 6 offenses, the proposal impact would have been a savings of 42 beds rather than a savings of 221 beds. So that's I would urge you to use 42 rather than 221 for doing apples to apples comparisons. So what that means then, and again, I apologize for that. Obviously, the risk here is that staff looks unprofessional because we're giving you something that's half baked. But my reason for doing that was I thought it would be more useful to you to have this today than to have nothing today. And with our limited resources, this was really all we can supply you.
Nate, let
Yes,
me
ma'am.
ask you a question.
Yes.
Is the reason that you originally didn't use the adjusted baseline? So I'm just reading in here that it says is it because on the sex offender grid the policy was the same as 2019? Is that what the original thinking was, or?
Well, so the footnote what we wrote in there was that A1 was the only proposal to retain the pre-2019 whole point policy. So it was unique in that way. All other proposals either abolished custody status or they stuck with the post-2019 half-point policy, or in one case, quarter-point policy, but some diminished form of custody status or no custody status at all. A1 is the only proposal to say we're still giving a full point for custody status in all cases that get a custody status point, or 2 points for repeat sex offenders. So that I think was the reason for it, but it's really I think a flawed reason because it just doesn't give you an apples to apples comparison. So that's why we chose it sort of as we were drafting this. But like I said, consider this to be a draft document. In the course of our discussion, we just haven't had time to fully vet it. If we were doing tomorrow's version would not say on page 2, except for A1, the only proposal to retain the pre-2019 whole point policy, and it would instead of having a bed reduction of 221 beds, would have a bed reduction of 42 beds. And Ann is on this call. Ann, feel free to jump in if I'm misstating something or you think you could shed more light. I'm not saying you have to, but
yeah. Can I say something?
If you think you could shed light on it.
Pardon? Yeah. If you might want to go back up in the document to where we say, so where we explain adjusting the baseline to account for the impact of the 2019 changes, you can see why that was necessary, because when we looked into these cases, 8% of them, again, these are cases with custody in 2019, 8% of them would have no custody status point because you abolished custody for stays of adjudication and original probation terms. And 45% of them would have a half a custody point because they were on custody for misdemeanor, gross misdemeanor, targeted misdemeanor, gross misdemeanor, or severity level 1 or 2 offense. So that's why the big difference in the between our first draft, when we started comparing it, when we started trying to, why we decided we needed to figure out a new baseline. By baseline, we mean what we did is we applied these changes to their criminal history and tried to recalculate what their presumptive sentences would be based on were they still eligible for a custody point or did they get a half a custody point? And that's why we have the big differences in numbers between our first draft last month and this draft. But I think this is important information for you that 8% would lose their custody point, we estimate, and 45% would get a half a point.
And that's what Ann found when she looked up those 25% of all the cases that were sentenced in 2019.
So we looked at 2,000 worksheets.
Yeah. So
and to try and figure out, what their custody was for.
Yep. Okay.
all right. So that's the impact in a nutshell of 2019. So A1. So it's a 42 bed reduction. So keeping that in mind when you're evaluating it. Let's see. I don't think you want us to get into the language, Madam Chair, do you?
Yeah, not today.
That might get a little thick.
Yeah.
But I would say if anybody has any, we did try to write this up as if this were going to happen in the guidelines. And if you have anything that you want to tell me about, I will say for each one of these, I found that it read much clearer if we somehow defined what custody status is first, and then defined. I added a term called a custody offense. There is a term similar to that called custody status offense in the current guidelines, but so we using those two terms, it was so much clearer and easier to talk about custody status points after that.
Yeah.
So if anybody has any feedback on any of these, I'd love to take it from you in a manner that does not violate the open meeting law, which basically means directly communicating with me, not as part of a group conversation.
Yeah, and so here again, I want to say great job. I did read every word, and I think you've done a really nice job of trying to translate our ideas into potential language for us. I would encourage commission members, as Nate said, if you see something, say something, because it is important to get it right. Now, between now and next month is a really good time to send any corrections or edits that you might have, because then we would have better language to work with as we're making our final decisions, our preliminary decisions in November.
And then, so 4D is evaluating the October custody status proposal. So again, I feel like I need to say a few words of explanation here. We don't mean to be stepping on your toes or assuming that it's our place to evaluate these proposals rather than you. Obviously, it's your place to evaluate these proposals. We just thought that we could start the conversation here by saying what might be considered to be some pros and cons. Reasonable minds may disagree with all of these, and obviously it's your decision how you evaluate these proposals. But to do all of these, we sort of looked at these different criteria: public safety, maintaining neutrality, reducing disparity, being rational, consistent, and proportional. This concept of parsimony, conserving limited resources, and simplicity. All of those are found either in the sentencing guidelines, statement of purpose and principles, or in the charter statute, other than simplicity. But I've heard from members of the commission, from Professor Fraze, and from, frankly, practitioners that simplicity is valuable. enough times that I don't think that's too controversial to use that as a guidelines principle. With respect to A1, the pros are, it talks about who's blameworthy. The pro is it focuses on multiple repeat offending as the trigger for additional punishment. So you have to have a criminal history score of 3 or more, which means, you have to have probably multiple felonies. I'm trying to picture how you get to a criminal history score of 3 or more without having multiple felonies. I mean, I guess you could have a juvenile point and a misdemeanor point and a felony points. So, but still, I mean, that's quite an impressive criminal record. And so it's really focusing on the history as being the trigger for additional punishment, which is not what the current guidelines do. And it's not what any of the other proposals do. They don't necessarily look at the criminal history score. It maintains the commission's past practice of having less tolerance for repeat sexual offending. So there's no criminal history threshold. This essentially reverts back to pre-2019 policy for sex offenders in all cases. There's really no difference between this and pre-2019 policy, other than I don't think anybody wants to go back to the days when 152.18 counted as custody status, or what's the other one? Could get a custody status point even if you weren't actually on custody status, if it was within the original term of probation. So none of these proposals, as I understand them, are proposing to resurrect either of those two policies. It could arguably be confusing for practitioners, since the policy works differently on the sex offender grid than the standard and drug grids, but it's really, that's not terribly confusing. So that's a rundown of 4A. Now, Madam Chair, what do you want to do at this point? Do you want me to continue on with 4B, or do you want to have a discussion about 4A?
I want to have a discussion about 4A, or about 1A.
A1, I'm sorry.
A1.
What was
A1.
I saying?
All right. So yes, so we've seen what it is. We've seen the potential impact. We have a few starter ideas for pros and cons, and so I'd like to open it up for comments that people might have. What I'm interested to hear from you is, are there other pros and cons that you see that maybe aren't mentioned here today? Are there other ideas about the rationale that make sense or don't make sense? Just what are your thoughts in general on this particular proposal? Anyone want to comment? Commissioner Larkin.
Thank you, Madam Chair. Here are my concerns with this proposal. I think it's recognized.
Commissioner Larkin, we're having a hard time hearing you, so maybe. Yeah.
Sorry, my mic was down.
Okay.
I think it's historically recognized that we've always had custody status recognized in the presumptive sentence, since going back to the beginning of the guidelines and before that in the common law. The idea being that if you're on some sort of probation or parole supervision for a prior offense and you commit a new offense, you're more blameworthy. So with that in mind, my concern is, if we go with this proposal, we're now saying, well, it doesn't matter that you're on probation or parole and you keep committing crimes until you rack up enough points. And then we're really concerned that you keep doing it. So it seems to excuse behavior that shouldn't be excused. My other concern is that, and again, is always, how would this play out? I mean, you could have somebody who's on probation for, let's say, first-degree burglary, a level 6 offense, or a felony DWI, a level 7 offense. They'd have a 1.5. Or somebody who gets a downward dispositional departure on an assault first degree, which is a 2-point offense. And if any of those people reoffended, they wouldn't be at 3 points. There'd be no consequence for reoffending, even though they're on probation or parole for very serious offenses. So I think that sends the wrong message, that a person might be on probation or parole for first-degree assault and only have a 2-point criminal history, therefore doesn't get any additional consequence if he or she reoffends. I don't know that that's the policy we want to adopt. And I also kind of oppose generally any proposal where we do one thing on the sex offender grid and another thing on the other grids. I know we already do that in some contexts, but in terms of simplicity, I think one approach is best for all grids to the extent we can accomplish that.
Okay, other comments?
Madam Chair.
Commissioner Estrada.
I would say, a pro would be some of the concerns that I brought up at the last commission meeting, in that not everybody who is sentenced to probation is on active supervision. Several people are either on low supervision or to the courts that do not have that one-on-one ability to get services and things of that sort. So one of the pros, I think, in this situation is that if by the time somebody is at the criminal history of 3, it is more likely that they have had that one-on-one supervision and they have had the opportunity to address some of the underlying issues that may be contributing to their criminal points. So I would say that that would be a pro in this proposal, is taking into account that population, which is a very large population, and really focusing on, I believe the director has it written here as the repeat offenders, and really taking into account that blameworthy, quote unquote, blameworthiness of it.
All right. Other comments? Wow, everybody's ready to go through these today. That's just amazing. Okay. All right. Yeah, I don't have anything. I actually think that what everybody just said sort of is all the things I thought of as well. So I don't have anything to add there either. Did you have a comment, Commissioner Moore?
Madam Chair, thank you. I guess being new to the Guidelines Commission, I am really concerned about the question of simplicity. The executive director mentioned that. I think that's a really imperative thing for us to consider. Practitioners, judges, probation agents in the district courts, frankly, trying to negotiate resolutions of cases and dealing with, limited time and limited resources. The more simplicity we bring to the guidelines, the better we're all going to be. And so I do share Commissioner Larkin's comments regarding that. And I am a little concerned. I'm open to the discussion about treating the sex offenders differently. I understand there's been some commission policies related to that. I guess I'd like to think more about that particular question as to whether there's a guidelines and criminal justice reason for singling those people out in a way that this proposal does. Thank you.
That's a good comment. I think in the sort of first draft of this proposal that didn't make it to the commission, we actually had criminal history score of 2 for sex offenders if it was on the sex offender grid, and then a 3 on the other 2 grids. So it was there was some difference, but because all of our policies are harsher for people on the sex grid, but it wasn't as big of a difference. And then ultimately that just didn't make it through that initial consideration, but it is an idea that could be resurrected if this is the one that rises to the top. Any other comments on A1? Commissioner Middlebrook?
Thank you, Madam Chair. I just had a question on the proposal. I know that they put in there that the waiver, that would take away the waiver for the district court to waive the custody status. Was there a reason for that, or would that be something that could be brought back into that proposal?
Thanks. I think that the rationale at the subcommittee level was that by the time a person has built up this much criminal history, we didn't really see the need for the waiver any longer because we have a sort of a different person in front of us at that point, as opposed to the first or second time offender. And we also thought for that situation, a downward departure might fit the bill. But that being said, I think again, if this is the one that rises to the top, then I think we should talk about, additional, if there are additional things, additional policies like retaining the waiver that would make this more attractive, then I think we should talk about that. Any other comments? Okay, so this one was focused on repeat offending. So that idea of, retaining the idea that you're more blameworthy if you commit a crime before finishing the older sentence, but sort of pushing that out a little bit, and really focusing on individuals who've had a chance or two and continue to reoffend. That's sort of the difference between this policy and what we have today. Okay, so why don't we go on to A2, talk about that.
Thank you, Madam Chair. So A2 is, I would say probably that, well, I mean, not trying to evaluate, but I think it's probably the closest to the status quo right now. In fact, it really doesn't make any changes to the language of the sentencing guidelines, sections 1 through 4 at all, other than a couple of changes to commentary to clarify. But all the changes are made to section 5, the sentencing grids. And essentially it takes what are now, I would call them 7-column grids, and makes them 13-column grids. Because between each pairs of columns, you're adding a new column. So as you know, the horizontal axis of each sentencing grid is the criminal history score, and it starts at 0 and goes to 6 or more. So that's 7 columns. And so this would take a half-point column and insert them in between each of the pairs of columns. The duration of the new columns would be the midpoint between its neighbors, its pre-existing neighbors, and the disposition of each new cell would be borrowed from the cell to its left. So in other words, the more lenient disposition would be the disposition that would sorry, I'm in the wrong one, 4A. So the more lenient disposition would be the disposition that would apply. So that's a summary of the proposal. As far as the impact of A2, that would be a 44-bed reduction. So there would be some longer sentences, because there would be cases where the half point would be rounded down, where they would get a lower sentence. There would also be some higher sentences. But there would also be some dispositional reductions, because in some cases, the offense would not only bump up to the next higher cell if you added the half point to a half felony point, it would move up to a whole point and get you into the next cell to the right. That next cell to the right might also have a higher disposition. So the net effect of this is a reduction of 44 beds for the whole population. As far as the text goes, I think it might be helpful to actually see that, because this is pretty easy to show the text. The text is just basically delete all the grids right now. And then what I'm about to show you on the screen is the standard grid as it would appear. So you'll notice that to make room for this, we had to first of all, turn the page sideways. And second, we had to landscape mode, I should say. And then we had to eliminate the example offenses that currently appear on the grids, just to make room for the other 6 columns that had to get added to this. But that's what the text looks like. Pretty straightforward. And then as far as the pros and cons for A2, the pros, it maintains the current policy of not having custody status outweigh the criminal history for prior low weight offenses. So remember, that's what the commission was trying to do in 2019 by creating the half point, was to say, and I think Professor Fraze echoed this when he was talking about his book last week, is we don't want it's not necessarily I don't think he considered it to be terribly rational to have the fact that you committed the crime be more severe in criminal history than the fact that you were on custody status for that crime. So this maintains that policy, and it clarifies what the presumptive sentence is, which of course is the object of this exercise. It would be clear what the presumptive sentence would be for people with half custody status points. The cons are it does complicate the grids. I mean, visually, I would say. I mean, it doesn't mathematically complicate them, but it does add a lot more numbers to the grids, and those numbers crowd out some of the words on the grids. I think some people might find helpful to when you look at the current sentencing grid, you can see, you know, what does severity level 3 mean? I don't know. And then you see, oh, there's some example severity level 3 offenses. I get it. There's a little bit of mismatch between the existing policy to round down felony points. So right now, if you have if you have like X 0.5 felony points, like two and a half felony points, that's rounded down under current policy to 2 points. So one might ask why that's not done for the half point as well, or why isn't it all added together and rounded down? So there could be some confusion for people doing back of the envelope calculations for plea bargaining. You know, might not appreciate the difference between the rules, and you know, that's always an awkward situation when you get to the sentencing hearing and you find out that the sentencing worksheet is different from what you assumed it was when you made the plea offer or you accepted the plea offer. So that's it for A2, Madam Chair.
All right, I'll open it up for comments or questions. Commissioner Ladd and then Commissioner Larkin.
Thank you, Madam Chair. I would just like to say that I think a couple of things on this proposal, from my mind as a practitioner and speaking to my colleagues, is this does simplify things, and it makes clear what we're supposed to do with this half a custody status point. And to that point, I feel as though this proposal honors the prior commission's work on this issue related to the half point, and it gives the intended effect. I sort of feel like this is the continuation of that work, because there was a lot of work with the prior commission in coming up with a rationale as to why we were going to have a half a custody status point in the first instance. This just allows it to function and give the intended effect of all of that, and I feel like this proposal honors the prior commission's hard work on this issue. I actually don't think that I don't really see the con, and I thank you, Nate, for explaining. I didn't understand what it meant when it crowds out example offenses. I didn't know what that meant. I mean, my grid looks like this right now, and it's an expandable deal, and I don't think, because there's 3 grids, I don't think the landscape of the grid necessarily makes anything more complicated. And I just think that having that half a point makes very clear what's going on. I also am not aware of the prior commission's discussion when they were working on this custody status point, if there was any discussion about the rounding rule related to the felonies. I think that's a different topic. And so how the half felony points are worked into the guidelines with rounding, I don't think that they should be. I don't see that as a con. I see that as a very different issue about how the felony points are rounded. And again, I think this example really does give full effect of the prior commission's work on this issue, and so I like it.
Right, Commissioner Larkin, and then I think Commissioner Estrada. Yeah.
Right. I like it as well, and in full disclosure, this was my idea. If the problem with the current half-point custody status point system is that it results in half-point scores and there are no boxes for half-point scores, it seems that the simplest solution is to simply add half-point boxes to coincide with those new scores. I think it's the simplest, easiest, and least controversial way of solving the identified problem, and it provides what is lacking, presumptive sentences that correspond with half-point scores. The benefits, I think, are that, again, it honors the work of the recent commission on this issue. The memo that we were given last time that talked about all the options the commission looked at to sort of solve the problem of a person getting more time based on their prior offense than their current offense, was resolved to everyone's satisfaction with a 0.5 point for custody status. And this is simply a way to further develop that agreement and put it into practice in a way that's not confusing. I also like that it does not change the way in which we provide the custody consequence. As Nate pointed out, it doesn't require us to rewrite the guidelines, which always leads to unintended consequences and mistakes, which I think is what we're dealing with here. Nor does it require practitioners or judges to learn an entirely new method of applying the custody consequence. They just use the current method and look at a different grid. And I appreciate that it might be convenient to have sample offenses in a column for comparison, but I don't know that that's not a reason to go with what might be the cleanest way to address the problem. The other things I like about it are that it ensures that every offender who has custody status receives a custody consequence. So there's uniformity in application consistent with guidelines principles. And I also like that it does not reduce the presumptive sentence for any offender, even though it actually reduces bed use. So I think that's a great outcome. So I speak in favor of this proposal.
I just want to, before we leave that, I just want to actually clarify. I mean, it has to reduce the sentence for some people overall, right? It's not, there's not a null effect. There's just a little bit of resorting that goes on with this one, right?
Well,
How would it reduce anyone's sentence?
Because it's new numbers. The numbers that are in between the grid, in between the cells are new. So some people were being sentenced on the cell below and some people were being sentenced on the cell above under the
But we
current
don't know
policy.
that they were being sentenced on the cell above appropriately. I mean, we're dealing with people that had a score of 2.5. And, you know, the debate was, well, do they get sentenced at a 2 or a 3? And we didn't have a legal case come up where the court would say whether or not you could sentence somebody at a 3. So, I mean, it's only reducing sentences if people with a 2.5 were being sentenced at a 3, right?
I think we have to let Ann. I think we'd have to let Ann respond to that one possibly, unless you want to, Nate.
well, I mean, I think I know the answer, and it depends. I think Judge Larkin's correct. It depends on how you interpreted the guidelines. Under the choice we made, which one could argue is an arbitrary choice, to use the EWS method of calculating what the status quo is, it did increase some sentences, because if you apply the EWS method, then people with, say, you have 5.5 felony points and 1/2 custody status points. So this is somebody who just commits a lot of drug offenses or something. So that person with 5.5 felony points and 1/2 a custody status point is going to look at a criminal history score of 6 under the status quo, and I'm putting that in quotes with my fingers, the status quo as we've defined it. And the way we've defined it is using the EWS method of calculating criminal history. So that person would get a break under this policy, because instead of having a criminal history score of 6, they would have a criminal history score of 5.5, which is, for the low level offense that I'm thinking of, a stay rather than a commit. So, but that's assuming that particular status quo. If you assume a different status quo, which is where a judge looks at that and says, well, the criminal history score is 5.5, I'm not going to sentence that as a 6, I'm going to sentence that as a 5, then there wouldn't be an increase at all. So, or I should say this would not cause a decrease in sentence. So I think it depends on how you interpret the current law, which is very difficult to do without clarification from the commission.
Okay. All right. Commissioner Estrada. Thank you.
As somebody who was sitting on the previous commission, I do want to clarify some of these assumptions about intent. And Commissioner Middlebrook may be able to shed some light on this as well. When we did talk about 0.5 point, we were under the assumption that the rounding rule was going to take effect. And if you remember kind of the assumption and why we're here today is because, you know, we thought, you know, the application, or we assumed that the application was going to be add them all together and then round down from there. Unfortunately, you know, that had its own issues. That was a proposal that was brought up, I believe, by our commission staff. And we voted that down. And the reason we voted it down was because there was still uniformity in the application of it. The results were different, right? Some of them were getting, you know, if you added it all up, you could end up at a 3, or you could end up at a 2. I think that this proposal does something similar where there is uniformity in applications, but some people are going to end up being on the higher end and some people are going to be on the lower end of that. But I think it's really important to talk about the intent of that commission, to the comments about if there was discussion on the previous commission about the rounding rule. There was discussion about the rounding rule. And I would say that a pro would, or a con would be that it does complicate it because it does not align with everything else that's in the guidelines that refers to rounding.
Any other comments? Commissioner Middlebrook.
Thank you, Madam Chair. Yeah, I would agree with Commissioner Estrada. When the previous commission, when we discussed this, there was this, you know, that was a compromise when we ended up with the final proposals that went through. And on the rounding, we did assume that they were going to be rounded down. I mean, with one of the biggest pushes that we had was trying to eliminate the custody status then. And we realized that these lower level half points would be rounded down. And so I agree with Commissioner Estrada on that point. We did talk a lot about eliminating the custody status, but we had, like I said, it was a compromise and we were all, you know, trying to work through everything. And so we had to do some give and take there. The one thing with the grid, with the half point, I do think that visually, it's very complicated. I think for practitioners, I think they really like the examples of the offenses for each level. This seems like, you know, we're really complicating the actual grid. I also have, you know, concerns about the confusion with where there's a half point with the felonies, because it seems that these two policies are contrary to each other. And so I said, I think I have concerns about that, that it's going to, you know, they're going to look at this grid with the half points, and a lot of, you know, probation, prosecutors, defense attorneys, and judges will think, well, I should use that half felony point, since I now have this half point grid. I think that is a concern.
Commissioner Larkin.
Well, I mean, just the obvious, we have the two rules that
I think
what the commission gave, we're not coming up with that now. And if there is something you could do is to eliminate the rounding for the felony and having scores. But I mean, I don't know that it's fair to say, well, this is confusing because we round for felonies, but not for this custody point, when that's the proposal you folks came up with and gave us to work with.
I want to respond to that one too. I would just say that for me, that this is the crux of my concern. I do think that having the half points on the grid makes it, you know, clearer when you have a criminal history score that ends in a half point. Like, where does that fall in the grid? So we've solved that. But the incongruity for me between the felony rule and this rule, I find that hard to sort of reconcile. Like, what's the rationale for treating them differently under those different circumstances? And it's my understanding, if I think back, you know, looking back at sort of the construction of the guidelines to begin with, you know, the rounding rule was put in place initially really for the benefit of the defendant. And so, you know, the initial commission made a conscious decision to have full points and to use rounding to address the situations where the full points didn't exist. So I do think that if we were going to go down a road where that is not, where we're not going to round, then I don't think it makes sense to retain the felony rounding. And so, but I also don't want to put on the table not maintaining the felony rounding, because I actually think that's the right rule. So I find those two policies in conflict with each other, and that's really for me the biggest issue that I see on this particular proposal. Otherwise, I think, you know, yeah, creating the grids the way they are makes it more clear. Commissioner Knudsen.
I'm just,
Am I mute?
yeah, I'm just trying to figure out exactly where we are. When I looked at the agenda, you know, it says resolve the custody status problem. And so I thought, or I believe that the custody status problem is that we agreed, or the Guidelines Commission at one point agreed that there is going to be half points. Is that correct?
The prior proposal did put that in place, right?
So would we change the prior proposal and now go back to rounding?
You're asking.
I mean, is that?
I don't think that's on the table. You know,
Well, right. I guess that's my point. I didn't think that was on the table. And so the issue still is, how do we handle a half point? And that seems to be what the complaints or the concerns are out in the field when applying our current policies. So when you have a custody status point or a half a point, how do you sentence in that situation where we're not rounding down? And so we have to take into consideration a half point and create something that deals with a half point that's different than our current guidelines, which deal with only full points. I'm trying. I think that's what my understanding of this custody status problem is that we have a half point. So now how do we accommodate and sentence according to a half point? And so if we don't have a half point grid, how have we solved anything, or how do we address that issue? So I just wonder, am I off base here? Am I understanding this correctly, or?
So I'll reply, and then Commissioner Estrada's raising her hand too. I'd say the only piece of history that you've missed, Commissioner Knudsen, is that we actually did have a proposal on the table last December to add the points together, the felony points plus the custody status point, and round at the end. That was the proposal. We actually took it to a public hearing. And then after the public hearing, there were members of the commission who weren't satisfied with that as a proposal. And so that no longer was on the table. So that would have been a simple solution to the problem. So that's not on the table. We had to come up with another way to resolve the problem. So what you have in front of you are other policy options that would also accomplish the goal of clarifying the guidelines and what you should do with custody status. So that's sort of where we're at. Commissioner Estrada.
You covered it, Madam Chair. I would just add that the reason the work group was put together was so that we could brainstorm, and that's exactly what we did. And that small work group was brainstorm a bunch of different ideas. We weren't limited to just trying to figure out how to implement the half point. We were examining whether this was the best policy or procedural change to begin with.
All right, any other comments on what are we on, A2?
A2.
All right. Hearing none, we'll move on to A3.
All right, thank you, Madam Chair. So the A3, so the A3 is the last of the A series. And if you remember, the A series is are the three proposals that would retain custody status as a factor in calculation of criminal history score modifications. And all three of these are trying to solve the problem that Commissioner Knudsen just raised, which is, what do you do with the half points? And they try to do this in really three different ways. So A1 tries to do it by just getting rid of half points and coming up with a system where it's still fair to have full points. A2 tries to do it by keeping half points and accommodating those half points. And A3, I guess, sort of doubles down on half points and suggests that it might even be appropriate to have quarter points. So here's how A3 works. A3 says that you get a full point if two things are true. So really the key to understanding this proposal and the key to making this proposal not seem overwhelmingly complicated, which it certainly can, and that's a potential con of this proposal, is the key to understanding it is understanding that what these two things are. One is looking at the custody offense. So unlike proposal A1, which was looking at the offender's criminal history, this is looking at what that custody offense was. And if that custody offense was a serious offense, and this is establishing that line at 4 on the standard grid, H on the sex offender grid, which is almost every offense except failure to register as a predatory offender. 4 would be sort of your person offenses. That's where you end up seeing, like when assault offenses are on the standard grid, that they'd be ranked at a 4. And then D4, which are similarly ranked offenses on the drug grid. So if the custody offense was a serious offense, that's one of the two factors. The other factor to look at is whether or not both the custody offense and the current offense are person offenses. And that includes DWI for these purposes. So if both the custody offense and the current offense are person crimes, then you get a full point. And the custody offense was one of these more serious offenses, then you get a full point if both of those conditions are true. If either of those conditions are missing, it's divided in half. And if both of them are missing, it's divided into a quarter. So if the custody offense was not a serious offense and the person was not in a custody status for a person crime when the current offense is a person crime, then you're looking at a quarter point. And if only one of those is present, then you're looking at a half point. And then it retains all the other custody status policies. Now, to accommodate the quarter point, this proposal would also change misdemeanor points to be, instead of worth 1 unit, they'd each be worth a quarter point. So that way you could have, say, for example, 3 misdemeanors plus 1 quarter custody status point would total a full point. And then this rule would incorporate that rounding rule that the commission rejected in January. Because otherwise it wouldn't make sense to have these quarter points. So that's 4A in a nutshell. 4B is the impact statement for I'm sorry, I keep saying 4A because the document is 4A. That's A3 in a nutshell. Thank you. So this proposal would have a savings of 53 beds, a 53 bed reduction for the whole population. So there would be some cases that would shift from probation to prison because if you think about these misdemeanor cases, you could have less than 4 misdemeanors have a meaningful impact on your criminal history, which isn't possible right now. If you have 3 misdemeanors, then it has no impact on your criminal history. Here, 3 misdemeanors would be worth 3/4 of a point, and that would have an impact. So you do end up with some longer sentences, some people going to prison, but some people shifting out of prison because every misdemeanor counts for something. But net, it's a reduction because of this reduction in custody status overall. You can only get one custody status point if the custody offense was a serious offense and both the custody crime and the current offense are person crimes.
Nate, can I ask for some clarification on this?
And I should say that the 2-point rule still applies. So this is like the first proposal, A1, no change to the current 2-point rule for repeat sex offenses. Was that your question, Madam Chair?
No, my question was I know that the impact statement should be treated as a draft, but it's a positive number, not a negative number. And you refer to it as a 53-bed savings, but this is looking like a 53-bed addition. So I'm just trying to figure out which direction we're really talking for impact.
I would ask Ann to answer that question.
Ann, are you here?
Ann, did you understand the question?
Takes me a minute to find the unmute. Yeah, it's if you look at the narrative in the 4B, it explains that there's actually 4 different effects of this. There's the changes in presumptive dispositions. Can you hear me? I don't have my.
We can. The problem that we're seeing, Ann, is that the pluses look like they're bigger than the minuses. So why isn't that a bed addition instead of a bed reduction?
Minus 23 beds from shifting from prison, plus 68 beds from plus.
I think it is an addition.
40. I don't know. I thought that I'll add it up. Maybe I filled those numbers in the wrong places. I don't know. We'll recheck everything.
Okay, can you recheck it right now, Ann, and get back to us when you get an answer? Well, I think we can move on to discuss the pros and cons, but that's a really important point to clarify.
I think,
yeah, I'm gonna guess since I'm just gonna guess what happened here. Like looking at those 4 numbers, I just added them together on my calculator, and it is plus 53 beds.
Mm-hmm.
The first line says the estimate changes would result in a bed savings of blah 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 blah. Well, that savings language is true for every other policy, so it just might be like a cut and paste kind of error.
Yeah, it might be a 53-bed cost, but
yeah.
But I would just
So
ask.
we'll hear from Ann. We can move on to the
Ann
rest
to
of the discussion
clarify.
while she's looking at those numbers.
Okay. Let's see. I don't think there's too much remarkable in the text. As far as the evaluation of it, well, I guess if there is pros, I mean, it maintains the current policy of not having the custody status outweigh the criminal history for the prior low weight offenses. And it arguably adds to proportionality and point assignment. Maintains past practice for less tolerance for repeat sexual offending. That's also true of A1 and A2. It's grounded in proportionality. The point allocation is based on the severity of both the current and prior offense. And it also talks about, I mean, Professor Fraze talked about this to some extent too, when he was talking about the idea of, I think his argument, if I understood him right, was that it's more rational to not just look at the fact of custody status, but look at what the custody status is for and what the current offense is for. And it seems more meaningful if the custody status and the current offense are both for the same type of thing. And in this case, it's more meaningful if both the custody offense and the current offense are both person offenses, as that's very broadly defined, includes DWIs. And then it does, if you like the idea of rounding after adding all the criminal history components together, then this is the only proposal that does that. But it does complicate the guidelines. It could cause confusion, and it does have an impact in terms of adding prison beds due to getting rid of misdemeanor units. So just just in case everybody isn't aware of the current policy on misdemeanors, because we haven't really discussed that. Misdemeanor units are what you earn for a misdemeanor, not points. And a unit is worth nothing in criminal history unless you have 3 other units. And then you get 4 units together, and that's equal to 1 point in criminal history. So and there's different rules for DWIs, but that's essentially it. So you can get 1 misdemeanor point, unless you're talking about DWIs. You can get 1 misdemeanor point only if you have 4 units together. Otherwise, you get nothing. And I would say maybe on the pro side, there is, that does have sort of a perverse effect in cases where you have 3 misdemeanors. A 4th misdemeanor can be worth a full point in criminal history, whereas a lower level felony is only worth half a point in criminal history. So you can have a perverse situation where you'd rather plead guilty to a lower level felony than that 4th misdemeanor, which I've always found odd as a practitioner, as a former practitioner, I should say. So that's the end of the pros and cons on that. Unless there are any, Ann, do you have an answer for us yet?
I think it is what Kelly said. We should have replaced, it is the total bed increase.
Okay, so that would be another con is that's a 53 bed impact. That's not insignificant. Commissioner Schnell, I don't know if you know what the per diem rate on that is, but that's many thousands of dollars for like lots of thousands of dollars for that change.
About $120 a day per bed.
So multiply 120 times 365 times 53 and end up with a pretty big number.
All right, thanks, Nate. And thanks, Ann, for checking that for us. Comments on this one? Did you, Commissioner Middlebrook?
Thank you, Madam Chair. I guess I have a question for Nate. Does this, were you talking about that there would be this quarter point for every misdemeanor? So there would not be the limit like there is now with the units. Is that how I'm reading this? That you wouldn't limit the misdemeanors to, other than on the DWI side of it, you wouldn't limit. So every misdemeanor that would be on the targeted would get a quarter point?
Well, there would still be the limit. There would still be the 1 point limit. But the problem is with the first 4. So the 5th one still wouldn't count, just like current policy. Okay. But the problem is the first 3 would count, unlike current policy. They would count for a quarter point. So that's the rub with the prison beds is that every misdemeanor would count, whereas right now a misdemeanor does not count unless he has 3 friends, and then he counts.
Okay, and then the second question is, am I understanding that you would add up everything, including a half felony point, and then you'd add the total up and then round down if there was any fraction?
Correct. Right. So this would be sort of doubling down on the rounding rule that the commission did not adopt, essentially. So it would be taking the unrounded sum of felony points, the unrounded custody status point or fraction thereof, and the unrounded misdemeanor points, adding them all together and then rounding down to the nearest. So 2 3/4 points would round down to 2 points.
Commissioner Larkin.
I think the discussion we just heard makes my point. This is far too confusing. And I mean, if we're committed to a simpler process and guidelines that are simple to understand and apply, this is off the charts in the other direction. So I would speak against it.
Any other comments? Commissioner Moore.
Thank you, Madam Chair. I will credit staff for some extra work and real thought on this one. This is an interesting proposal. I do share the concerns regarding complexity. I think this would be a real labyrinth for practitioners. There are some components of this that are interesting, and I guess I'm not ready to reject it categorically, but I am concerned that adding quarter points and a multi-tiered grid with regard to which offenses it applies to, custody incurrence, I think is going to create some serious questions in the practitioner community. I really can't emphasize enough the need for the guidelines to be understandable and comprehensible to everybody, and particularly those who are using it in the district court. I could see a lot of worksheets coming back, you know, with mistakes in them, frankly, submitted by probation on this.
That's what our new fancy manual or electronic worksheet is going to take care of, right? Right. It's all going to calculate it for them. Any other comments on this one? Commissioner Ladd.
Thank you. I think I would just echo the concern about it being complicated, not only just to understand and apply, but I think it's going to create a lot of work because it leaves a lot of room for error, which I think is not good for anybody in the process, including the defendants that this would apply to. The one pro that I do see in this, and it's an element that I've liked, and I understand that there's more to it, and perhaps it lives in another proposal, is the idea of just rounding all the points together, whether it be custody status or whether it be felony points, and then you round down the sum total of that. I know that we didn't get very far with that previously, but that is a component that still is of interest in terms of where that goes with whatever proposals we land on. But when I got this, the first thing I wrote in big capital letters was super complicated, and I am all about making this more simple. And again, I can't tell you how often I have heard that from my colleagues across the state, that the guidelines are not that right now. And so for that reason, I think this current proposal is just not sustainable for practitioners, and I don't think that gives clarity in sentencing for anybody.
Anne, you wanted to make a comment?
Yeah, well, that's what we did. That's the method that we used for determining the baseline situation, because that's what the EWS system is currently doing. It's adding up all the components and then rounding down. So it's taking all the felony weights and then adding in whatever the custody weight is and then rounding down. So that is what the EWS system is currently doing, but that was because we erroneously told it to do that before the issue of how the guidelines were written to say round down the felony points only was brought to our attention. So that is the, when we told you that the base impact for the base of the base was a 141 bed reduction for the whole population. That's applying that system of just summing everything up and not rounding until you get a total sum at the end.
Thanks.
That's what the EWS system is doing now.
Great. So what I'll say about this proposal is I appreciate the work that went into it. And, you know, the one thing I do really appreciate about the proposal is that it sort of eliminates this fiction of the unit versus the points. I've always thought that that was a distinction without a difference in the sentencing guidelines. I know that the original commission was trying to, you know, keep misdemeanors or minimize the impact of misdemeanors in criminal history. And I don't disagree with that approach, but sort of doing that with this unit versus point distinction just kind of never made sense to me. So I do like sort of breaking that wall down. I do like the way this proposal breaks that wall down and then just makes us, you know, sort of reckon with what's the value of all of these different components together. But I am also concerned about the complexity of the proposal. I mean, I also like that you picked up on that this picks up on Professor Frase's, you know, concept about repeat offending repeat similar offending, like repeating in the same vein, because that is demonstrating specialization, and that individual is a bit of a different person to deal with than somebody who might be committing a bunch of different crimes, especially when we're thinking about more violent crimes. So I do like those two things, but I'm afraid from my perspective, it feels too complex. And I share the concerns that have been stated today about how it would play out in the field. And while I do know that we could program all of these things into the EWS system so that we would minimize errors, I'm concerned that just the confusion, because the EWS system comes in so late in the game. I know that we're also working on some like pre-sentencing worksheets that some locations are using those as well. But it's just so late in the game that I'm afraid that most practitioners just won't have the benefit of that calculation. So I'm concerned about that as well. Commissioner Moore.
Thank you, Madam Chair. I'd just like to echo 2 points that have been made in this discussion. Commissioner Mitchell, share your concerns regarding the units. As a practitioner and as a judge, I have found that to be confusing and frankly difficult to apply. And for purposes of future, I guess, compromise on this issue, I think that is something from this that is absolutely worth thinking about. And Commissioner Ladd's comment about the eliminating dual or different rounding rules and having one rounding rule that applies to both status and points, I think might be appreciated. And that sounds like it was a topic that was part of the debate that went into this last one to 2019. And maybe it's something that at some point we could reconsider, because I share the concerns about having different rules, rounding rules here. And while the grid and I guess it was A2 that establishes the half points, on its face made sense, I think it does invite confusion, people thinking, oh, well, now we can round everything, and potential trouble in that regard too. So thinking about a common rounding rule, I think might be beneficial for future discussion.
Commissioner Ladd. I'm sorry, Commissioner Larkin, wrong L.
Oh, sure. I thought it just might be helpful to point out to the new commissioners why the commission, including the chair, decided against the rounding rule that had been proposed, which we took to a public hearing. And the concern was that the only way you would end up with a half point under the current rules was as the result of a half custody point. And if you were somebody who had, 2.5 criminal history points, and then you got a half custody point, you'd bump up to a 3 and receive a consequence as a result of that half custody point. But if you were somebody who only had a criminal history score of 2, and then we added on your half custody point, and it wasn't rounded up, then the custody consequence wouldn't be imposed on that person. And I think Professor Frazee pointed this out in his comments that, it resulted in unequal application of the custody consequence, if you will. I mean, you only really took a hit on your sentence as a result of your custody status if you came into the score with a half point score to begin with. So that's why we tried to think of other ways to do this. And I don't know whether we talked about just, well, let's not round anything down. But I think the goal was, when we went into this work group, was recognizing that custody status is different than criminal history points. How do we come up with a solution where the custody consequence applies equally to everyone so that it's uniform, consistent with the guidelines? And I hope that's a fair recitation of where we were coming from.
Yeah, I would say so. Thanks for pointing that out. Thank you for the explanation. Okay. Any other comments on this proposal, or having been through all of the three sort of proposals that retain the custody consequence within the criminal history score. I mean, now that we've sort of talked through all of them, has any thought occurred to somebody, I know we've moved off the first two, but has any thought occurred to someone that maybe they didn't get a chance to make earlier, that they want to make sure that they voice now about any of these three proposals, just thinking about these three? Okay, sounds good. All right, so I'm thinking let's do one more and then we will take a short break so that we can, I know like logically it makes sense to break here, but I like to break when you're past the halfway point instead of in front of it. So that's what we're gonna do. So let's move on to B1.
Right. So B1 is, so we've now moved on to the B. So we're abandoning custody status and criminal history and repealing custody status. So all of the Bs have B1 as a subset of it. B1 is pretty straightforward. We're simply repealing the custody status point in criminal history. So essentially it's taking 2B2 and we decided to not renumber the guidelines, which as we typically do in our text. I'm sorry, I guess I'm jumping ahead to the text because there's not much more to say about the policy. It's very straightforward. Custody status has no impact. It's only the fact of the criminal history, the underlying offense that was committed, not the fact that you were on custody status for it that affects the presumptive sentence. We kept 2B2 intact and just put repealed on it rather than have to renumber everything that came after 2B2. That's all I wanted to say about 4B, or 4C, I should say. Oh, sorry, I skipped 4B. 4B is the impact. So this would have a significant impact, 536 bed reduction compared to the adjusted status quo. And I believe that's significantly smaller than what we quoted you last month. And that's because last month we were looking at the 2019 sentences as opposed to the adjusted 2019 sentences, adjusting them for the Commission's 2019 policy changes. And then let's see, the pros and cons. I already talked about the text. The pros and cons. So, just sort of generally making sentences less harsh, recognizes more recent research indicating that deterrence isn't effective at reducing crime, puts more emphasis proportionally, the part of criminal history that's left is actually criminal history. There's an argument to be made that custody status doesn't really fit under the umbrella of criminal history because it's not criminal history. It's instead of looking at the defendant's past, it's looking at the defendant's status on the day of the offense. So it's really a unique part of the criminal history. This really sort of purifies criminal history to only be looking at the history of the defendant as opposed to what was happening at the time of the offense. Really the severity is supposed to capture what's happening at the time of the offense. Recognizes the potential for increased punishment. So really, if the person is on custody status, whether that's being in prison or being on supervision, there's in all likelihood some sort of sanction that's available to the state that would punish that as opposed to incorporating into the presumptive sentence. And it certainly does simplify the guidelines. I would say it would be a toss-up between this and A2 as to which is simpler in terms of simplifying the guidelines. A2 makes the fewest changes, so it's simpler in that way. It only changes the grids. But this really pares down the guidelines quite a bit. The cons is the perception that this doesn't adequately address the blameworthiness of an individual who commits a new offense before completing the sentence for a prior offense. There just seems to be something almost visceral about increased culpability for someone who is committing an offense while they were being watched, if you will. reduces the sentence for too many offenders, especially concerning for repeat sex offenders. And the concern that now is just not the right time to reduce sentences because of a popular concern about the increase in crime rates. So that's the end of the pros and cons on that, Madam Chair.
All right, open up any comments or questions here. Commissioner Larkin.
Thank you, Madam Chair. As I indicated, I believe at the last meeting, I opposed this because I think it would be a major change. I think we've been told that a custody consequence has always been included in the guidelines. I believe Professor Frazie's paper indicated that the custody consequence has always been a part of American common law. The Commission studied, considered, and rejected this proposal in 2018, and I recognize that that was a compromise decision, but I also recall asking Professor Frazee at the last meeting, what do we know now that we didn't know then that would justify revisiting this? I mean, in terms of academia, and he really didn't have any new reasons that we would make this change. And lastly, I just asked, how do we possibly justify such a change now with violent crime at historic levels? I just think this is not something that's going to be well received by the legislature next year if we were to do this.
All right, any other comments? Commissioner Ladd.
Thank you. One of the things that I see here that is a concern, other than it seems to be a pretty radical departure in terms of history and how we're treating custody status. One of the things that I noted, and it jumped off the page with me, was while there was this bed reduction for the whole population, the number of cases that would be moving from prison to probation was quite substantial. And for community-based services that have in the past failed, and those people have ended up executing their sentence, and then they come back into the system, and now they're put back on probation because they're not, the custody status point is gone. The concern that I have is the resources for counties to address the shift in population locally, and how to address that population when there have been issues in the past with complying with probation and doing what they're supposed to do. And so I see that as a concern for public safety, because now these people are in our community and the services aren't resourced, and they're there only because we're not recognizing that they are a person who otherwise could have had a custody status point and would have had a different consequence. And so I think there's a shift of resources there that would impact public safety at a community level, in addition to the other concerns that are outlined here for the cons.
Any other comments? Oh, Commissioner Estrada.
I just want to point out again, and I would encourage the new commissioners to, if you have time, I know time is limited for many of us right now, but if you have time, really going back to the research that was presented over and over again during this time that we started looking at criminal history and what changes we wanted to make regarding criminal history. More and more we are going into making decisions that are based on evidence-based practices. And I know that that's a huge shift, but I think it's important that we need to really look at what the data is showing us. For years, the data has showed us that incarcerating people for longer periods of time or having more jail time on over their head does not make an impact. It does not deter people from crime. In fact, research shows that the longer people are in prison, that can often have more of a negative effect. I would like to talk about resources. We are, definitely lacking resources in many areas of the criminal justice system, but I don't think that that's a reason why we shouldn't do things that are appropriate. And in regards to doing things because it's always been there, to be quite blunt, this country has done a lot of things that we have always done, and they're wrong. Some of it is wrong. There's a history of lots of things that are wrong, and that idea of, well, that's how it's always been. And again, I know that change is hard, but we really need to kind of, as a commission, look at that all together and really focus on what the evidence is showing us, what data is showing us. And I'm not going to go into the whole like, well, statistics and things of that sort, because we had multiple presentations over multiple notes or months, and it's way too much to try to sum up here. But I really do think that this is something that that as a commission we should consider. Also, as Commissioner Middlebrook pointed out, there were several of us who were looking for or advocating to have the custody status point removed at the last commission, or with the last commission, when we were taking this into account. And yes, it was a compromise. Part of that compromise include language and changes for specifically repeat violent offenders. Some of that compromise included the fact that there was a waiver attached to this. Some of that compromise included the fact that when somebody is discharged from probation, they're completely done, which wasn't always the case. If somebody had a 20-year probation term and they were early discharged and they completed or they committed a new offense, they were still getting a custody status point. So I would also encourage our commissioners, our current commissioners, to look back at the proposal and all of the changes that were done in there. This was very much a package deal when we voted on this. And the data, as far as what has changed, Judge Larkin, what has changed is that these other things are not on the table right now. What has changed is that, you know, we're looking at this specific instance because what we came up with at that time, we didn't anticipate that it was going to be, how should I say, applied differently. We were short-sighted in that.
I will come back to you, Commissioner Larkin. I just want to make sure we get everyone first round comment in, and so I'll make a comment as well, and then we'll see if anyone else has one and come back to you. You know, so I'm the one that put this one on the table, and you know, really, I originally supported the rule of adding everything together and rounding it down. As that became not workable solution, you know, I really thought about what's the purpose of custody status and why do we have it? And the more that I looked into sort of how it works, the less it made sense to me personally. Like, yes, I understand the visceral reaction that somebody has committed a new offense before they've even completed the old one. And, you know, we all want to, you know, you just sort of intuitively think that it's right to punish that person more harshly this time around. But I think that, you know, we're forgetting a couple of things when we think that way. One of those that to me is it's a one-time consequence. So this person, you know, if they just happen to still be on their prior offense when they commit the current offense, it's going to increase their criminal history score, but just once. And if they come back again, but they have completed their sentence by that point, it's not going to be that custody status point. It's not going to stay with them. We're going to kind of reset. And so I find that to be not uniform in application in and of itself. And so it's like, sort of, why is he more blameworthy in one situation, but not the other, when now he's committed even another offense? When we looked at, you know, how custody status is applied today, I think we also have to take into account the fact that the majority of people who are sentenced under the sentencing guidelines receive a stayed sentence, not a prison sentence. And we saw that in the data that was provided today. So it's a stayed sentence. So the people that are being sentenced to prison are the ones that are being hit the hardest with custody status today. Their time is going up for sure. And the people that get pushed across the line into prison, they're getting hit hard. But the majority of people are not in those zones, and they're actually in the stayed portion of our grid. So now let's look at the stayed folks, and let's think about the operation of custody status on those individuals. There's a big chunk of those people who have a stay of imposition. So we're never even going to pronounce a longer sentence length to hang over their heads. If they do fine, it's like custody status never existed for them. It doesn't impact their sentence one way at all. If they have a stay of execution, okay, we're going to pronounce that more severe sentence, but it may never be applied to that individual unless they are revoked. We're never going to see the impact of that custody status enhancement. So from my perspective, we're already in a situation where the custody status consequence is not being applied uniformly to people across the grid. And I can't think of a way to make it apply uniformly to people across the grid. And I'm also not sure anymore whether we should apply it to people across the grid. I talked last month about, the person who's coming back with a repeat drug offense. If their crimes are driven by addiction, they need treatment. They don't need additional punishment. Someone who's coming back with a new sex offense, okay, maybe we need to think about that punishment consequence more harshly, but those are two different situations. And so, I'm just beginning to wonder if we need a more individualized approach for individuals. And then I just want to, remind everyone that we do have all these other consequences that flow from the fact that you're on custody status. So if you're already on probation, you're gonna get a probation violation because you have your new offense. So there's an opportunity there to already increase the consequence for the individual. If you're serving time in prison, you're gonna get disciplinary time. Commissioner Schnell can tell us about that. You're not getting out as quickly as you thought you were before. So there are already other mechanisms that come into play that can account for the fact that this person was under some form of custody status. So that's why I brought this proposal forward, because I see a lot of pros with it as well. I'm not as concerned about the issue with rising crime rates, because most of those, where crime rates are rising, if they're not rising across the board, they're rising on the more violent end. We actually don't have, most of the people who are receiving these custody status points are not in that group. I just don't, and receiving a custody status point is not going to stop that crime from occurring. That crime is occurring for other reasons, and there are other mechanisms that we need to be working on as a community to try to bring those crime rates down. So those are the reasons that I brought this idea forward for consideration. So I saw Commissioner Larkin's hand, Commissioner Hansi, and then Commissioner Larkin, and then Commissioner
Schnell, I
Larkin.
think, too.
Oh, and Schnell, did you say, does everybody want to talk now? All right, we haven't heard from Hansi, so let's hear from Commissioner Hansi, then we'll hear Commissioner Larkin. You've been patiently waiting, so then we'll go to you, then Commissioner Middlebrook, and if anyone else wants to get in, I'll take the queue again at that point. Commissioner Hansi.
Thank you. I don't have much to add. I just want to reiterate the things that have been said, and just really call to the fact that there is no data that harsher sentences are reducing crime anywhere. We've had enough studies for that, and because it is what we've done before, that should mean give us more of a pause to do something different. As someone who lived a life where I'd been on probation, I'd been under supervision, I had continued to get, and this custody status point has affected my life. I can tell you just, it doesn't, no one is out there going, oh, I'm on probation, so I better not, continue on with my addiction. I better not do these things to survive. I better not do those things, because they need resources. And are we going to continue with a punitive system that has not shown to work anywhere in history? Or are we going to switch over to a more rehabilitative and supportive system? I don't see any reason to continue with having custody status points. I don't even see it in, for any crimes I don't see it at all being helpful. I think that we need to move on and do something that is more equitable.
Right, thank you. Commissioner Larkin.
Thank you. I'm very mindful of the studies that say, longer prison sentences don't reduce crime. Sending people to prison doesn't rehabilitate them. But I guess the question I have is, what are we going to do instead? I mean, what I'm concerned with is not so much about custody status. My concern is, reducing sentences across the board, doing it in a way that's going to take people who would have gone to prison and put them on probation, when I'm also being told the resources aren't there to give those people the services they need to rehabilitate such that they won't pose ongoing problems in terms of public safety. So, I mean, how do you fix this? I just don't see how you say, well, longer prison sentences don't deter crime and longer prison sentences don't rehabilitate people. So the answer is to go to a rehabilitative, supportive system. And yet no one tells me, well, what is that system? Who's going to run it? What does it look like? Who's going to pay for it? Because if you just open the prison doors and let the people out without those services in place and without some research that shows that particular services have been effective in terms of rehabilitating, we're compromising public safety. I just, what I never hear in these discussions are, okay, well, here are the programs that work. Here's what we should do instead. I simply hear prison doesn't work. The threat of a punitive sanction doesn't work. Therefore, we shouldn't do that. Okay, what do we do then instead? That's my question for the group. Because if you simply say, reduce the sentence, don't send people to prison, and we don't have an answer for what we're going to do instead, you are not being responsible for our main charge, which is ensuring public safety.
Commissioner Schnell.
Madam Chair, Commissioner Larkin, I hear what you're saying, and I think it is. I think when you start to look at the impact, and I really appreciate you raising that question of the what else. And I think it goes a little bit to what Commissioner Estrada was talking about when we look at evidence-based practices, because I think there are a number of studies that actually demonstrate effectiveness in terms of intervention and improved outcomes. Those are the things that I think need to be doubled down on. I think when you raise the question, and I think I'll go back to Commissioner Ladd's comment about the taxing of the resources, and yet you look at the resources involved in this 500, let's just say 500 beds, and look at what the amount of money that we're investing in that intervention that doesn't work beyond incapacitation generally, and use those resources to invest in the kinds of services that are needed at the community level. This is the whole justice reinvestment model. That is a solution that I think speaks to system effectiveness, which perhaps is one of the things I've said before, and I would maintain, is that sentence rationality and proportionality is, I think, critically important. And I share your sentiments for public safety, but I also want to make sure that what we do works, and that it produces a better outcome. There is no perfect outcome. There's no magic bullet, but a better outcome. And I'm concerned that we continue to use policy that perhaps if we look less on use of that bed space and reinvest it into the community resources that may be necessary, perhaps we would see less reoffending overall, making custody status less of an issue, perhaps. And so I really appreciate you raising the question of effectiveness and the question of how do we begin to address this. And certainly this is a bigger issue than just us. It's certainly a legislative issue. They would have to be the ones to make the decision around the reallocation of resources that would otherwise be used to fund these beds that we're talking about. But I do think it is absolutely the right question. So thank you for raising it.
I want to jump in here quickly, and then Commissioner Estrada and Commissioner Larkin, you can make a comment. You're reminding me that we've sort of been reticent in our duty because this commission has not been informed formally that Minnesota is in a justice reinvestment program now. And part of what, and that's been the leadership of our state signed an agreement to do this project. So that's the Chief Justice of the Supreme Court, the governor, and the leader of the Senate and the House. And part of what's going on within justice reinvestment is that there is some work being done to figure out, what the funding formula is for community supervision, and whether we are adequately funding community supervision now, or whether some revisions need to be made to that formula, and what minimum services need to be available in every location within the state. So that work is going on right now. And I think other work will go on as well. And I think as a commission, it's part of our duty to actually answer that question that you just asked, Commissioner Larkin, which is, prison is, I would say the response is prison is not the place to spend those dollars, but put those dollars in the community and make sure that, we have talked about the rural areas of the state, especially not having the same level of services that are available here in the Twin Cities. Well, let's make sure that those rural areas have it. And I think that, part of our job is to make recommendations to the legislature and adequately funding community supervision, making sure those services are available and that the supports are out there in the community. I think that is something that we should be saying needs to be done. I think what I'm saying here is I don't think custody status is the answer, but better supports in the community are the answer. Commissioner Estrada and then Commissioner Larkin.
And I agree with Commissioner Schnell and Madam Chair. I'd also say, the pandemic over the last 18, 19 months has really shed light on how the Department of Corrections and probation across the state has had to adjust and be creative, right? Because a lot of people who would have ended up in prison or sentenced are getting downward departures, or people are being released from jail. And there was a need, and there is in a lot of places, there is still a lack of resources. However, what that did was it showed us that we had the ability to contract with community partners to provide more services. Hennepin County has just created additional contracts. We're getting trauma-informed stuff. I just went to the MACPO conference, a couple weeks ago, and to hear what some of the smaller counties are doing, they're also kind of investing in community programming so that we can keep people back in the community, get rehabilitation, address the cognitive skills, address the criminogenic needs, address the risk factors, and do that case planning so that we can save those dollars that would be previously spent in prison beds or on prison beds and put it back into the community. So yes, we do have an obligation. I think we need to continue to remember that public safety doesn't always equate to putting somebody in jail. Public safety can also mean helping people rehabilitate in the environments in which they live in the communities in which they live in. And to Commissioner Schnell's point, it is that reallocation. And yes, it does come from legislation, and it brings me joy to hear about the program that Chair Mitchell just talked about. But those are just examples of what we are doing right now. In the last 19 months, I think everybody has seen that, more and more people are not going to jail, and we have been adjusting accordingly, and really, making those partnerships.
Commissioner Larkin.
Yeah, I have a hard time seeing the data that says we're in a position right now where we can reduce sentences, shorten prison sentences, not send people who would otherwise be going to prison because evidence-based practices tell us that there are a way to treat these people and the programs and resources are there to do it. So my concern is, you can't open the prison doors until you've got the programs in place and you have the money there to do it. I mean, what I read in the papers is people were released early from jail because of COVID and they went out and reoffended. I was a public defender for 13 years in Hennepin County in juvenile court. I mean, that is such, and that was at a time when they actually had lots of programs, very intensive programming for kids. Some made it, a lot didn't. So when I hear people talk as if like everyone who's in prison could be rehabilitated if we just got them out of prison and gave them services and we wouldn't need prison beds, I think that's completely unrealistic, just based on my experience in that field. There are some people you're not going to rehabilitate. They are going to have an antisocial criminal bent and they are going to be very dangerous. And we see, we just paper this morning, 2 cars riding through Minneapolis, shooting at each other, crashed, hit an innocent person on a scooter and killed her. Well, what were the needs of those 2 people in those cars who were driving down the road shooting at each other? Were they doing that to survive? I mean, there's a whole class of people who are committing very dangerous offenses, and I'm not hearing that there's a program that's going to reform those people. I get drug use, I get poverty, I get that people need help and support, but I don't know that there are programs for all of the people who end up in prison. And my experience as a public defender was you had to work pretty hard to end up in prison, at least in Hennepin County. People were given every opportunity to be on probation. People had violation after violation after violation. Programs were made available to them. They didn't take advantage of them. I wish it was as rosy as you folks are painting it, but I don't think it is.
Commissioner Schnell, and then Commissioner Middlebrook.
Madam Chair, thanks. Commissioner, and I just want to be clear, I don't think that my comments, I hope, were not taken as a rosy picture, because I get, I understand completely that there are people who won't go with the program. I understand that. And I think we all, we see that, we know that. And yet, I really want to be making sure that we're talking about the same thing, because I don't see custody status as the fix to that either. Now, I'm not saying that, and as I said, there is no magic bullet for this. There is no single cure. But I think, a balanced approach to how we look at this, and we're looking at anecdote, which, trust me, the case that you're referencing is horrible and horrific, and there absolutely has to be accountability in these cases, absolutely. And I don't hear anyone arguing against that. At the same time, I think we're trying to balance the issue of custody point, and to what extent custody point addresses the extreme cases that you reference. And I don't think we're talking necessarily about the same thing. I want to be clear about that, and I don't want to I hope the debate doesn't get characterized in those who are Pollyannish and those who are realistic, because I just think that that's not the case. I think you have to look at the totality of the circumstances, the data, and I certainly don't want to say for a minute that there aren't those people that simply need to be locked up, and they need to be locked up forever, and that we have those cases. There's no doubt about that. So I don't want my comments to be regarded as being dismissive of that reality.
Okay, Commissioner Middlebrook, and then Commissioner Moore and Commissioner Larkin.
Thank you, Madam Chair. I just was going to say, I think we're getting a bit off topic. And I think we need to bring it back to the custody status point. I don't think anybody here is saying that everyone in prison should get out and get put into a community-based program. I didn't hear that, and I don't think that's what anyone is saying. I think that for me, the custody status is a double counting, because the person that's on the custody status is already getting a criminal history point for their prior that they're on the custody status. And that's always been the concern with that double counting. I also think it's really enlightening to see that 2/3 of the people that are getting a custody status point are getting state sentences. So we're talking about that custody status is not reducing sentences. They're already getting state sentences. And going back to, reducing sentences, part of things that we need to look at too, and it goes back, when we started the initiative on the Drug Sentencing Reform Act, we knew there was going to be some reductions in sentences, and they needed to be that way. And the same thing with the proposal on all of these different criminal history points, eliminating the custody status for people that were no longer on probation. All of those, they also had the effect of reducing sentences. But if you're looking at it from that standpoint, that's not what we're looking at. We're looking at, it needs to be applied uniformly. Each case is different. There's all the individual factors, and the chair talked about that really well as far as how that's used. And there's so many situations where, they're on custody status, but they're maybe at the end of it and they commit a crime because they're an addict, because they need to be able to survive. So they're committing a new crime, but is that really reflective of everybody, so that they should all get an increased sentence because of that? And I think that's what we have to really balance. And it seems that it's a much better approach to look at it individually. There's a lot of options out there for, penalizing someone who's on custody status that commits a new crime. And we've already gone over that. But, as a public defender for, almost 30 years, I have seen all kinds of cases, all kinds of situations. And it just seems that the custody status is not applied uniformly. And it does double count that prior conviction in that whole criminal history allocation. So.
All right, thank you, Commissioner Moore.
Thank you, Madam Chair. For those of you who don't know me, I was a 25-year resident of Nobles County, Worthington, Minnesota, where I worked as a county attorney and then a district court judge for 8.5 years before a job change brought me to St. Paul. And what I have seen in the trenches, so to speak, is echoed by many of the comments that have been made here today. The resource disparities in greater Minnesota are a significant problem. Commissioner Ladd is right on target with that. I'm sure Wadena County and Nobles County probably have some similarities in terms of demographics and poverty rates and those types of issues. I try to be a realist about people, but Commissioner Larkin speaks truth about the reality of some people in the criminal justice system. That's just the sad reality. There's no amount of programming, treatment programs, et cetera, that are going to change certain people. On the other hand, I have also seen some amazing turnarounds with people that have been given the opportunities for problem-solving court, for other types of diversions away from the criminal justice system, that tell me that focused, targeted programming can work. So I don't think it's an either or issue. But bringing it back, as Commissioner Middlebrook, I think appropriately does, to the issue at hand here, I just worry that this particular proposal seems to me to be a little dramatic in the effect that it would have. And I guess I agree with the concerns relating to the timing of this. I'm not sure, without having a more comprehensive discussion regarding alternatives and programming at a community-based level for those who would be benefited by the custody status point, that we'd be, potentially sending a concerning message. So this goes a bridge too far for me, but I think the discussion that we're having hopefully could build some bridges for coming up with a reasonable way to deal with this. And maybe Commissioner Middlebrook or Director Wrights could remind me, I haven't been applying the guidelines as much over the past year, but remind me where the custody status point can be waived. Is that on only certain offenses, or is that a uniform? And maybe Commissioner Middlebrook or the Director Wrights could remind me on that.
Either of you, go ahead.
Thank you, Madam Chair, if you're calling on me.
Sure, go ahead.
So my recollection is there's a limited, so if either the custody status offense or the current offense is on a particular list, then it's not waivable. Otherwise, it is waivable. The list includes, I think, all sex offenses and otherwise some fairly serious offenses on the standard grid and drug offender grid. And I think there's also a severity level. Maybe I should look at that.
Do you remember, Commissioner Middlebrook? Oh, it's in here.
See, there is a severity level cutoff there as well. So basically, it's unless, let's see. It's 2B2E. So it's severity level 8, 9, or 10, or 11 on the standard grid. Any offense on the sex offender grid except for failure to register as a predatory offender, and D8 and D9 or above on the drug offender grid. Any severe violent offense on the Commission's severe violent offense list, fleeing a peace officer with great bodily harm, or an attempt to conspiracy. So if either the custody offense or the current offense is one of those offenses, it's not waivable. Otherwise, it's waivable if the public safety considerations are met, and that's really in the discretion of the court.
Right, and when this was a helpful addition, I thought, to the guidelines, and gave the parties the flexibility in appropriate situations to agree that this custody status point could be waived, but it was based on usually an offender-based circumstance based upon their perceived amenability to services and treatment. And to me, that seemed like a reasonable way of addressing the custody status dilemma with some of these people. And so I think that by, getting rid of the entire issue, we throw out that discretion, because obviously there are some cases where I think custody status is totally appropriately applied. And so I hope people keep that in mind too.
Okay, thank you. Commissioner Larkin, I'm gonna say last comment, and then we're gonna take a short break, and then we'll finish.
Nothing further.
Nothing further? Okay. All right. Well, let's go ahead. I think that some of the other proposals also get at some of these other concerns that have been raised through this discussion. This has been a really good discussion, I think. So thank you. But let's take a short break. Let's take a 10-minute break. It's 3:25 on my clock. We'll go to 3:35, and then we'll come back and work through those other ones. Oh, now we're back in session? Okay, and the recording is back on?
Yes.
Okay, perfect. All right, so welcome back, everyone. Thanks for your patience there. We've made some really good progress through the proposals, and I want to keep going. I think this is working out pretty well. So we're going to move on to proposal B2, and I'll ask Nate to explain that one.
Thank you, Madam Chair. So this is one of the B proposals, which means it starts with B1, which is repealing the custody status point from criminal history, but the rest replace it with something else. And B2 replaces it with a mandatory sentencing enhancement. So you've seen this before at the last month's meeting. This adds to the presumptive sentence a fixed number of months, well, a percentage of months. It's equal to 10% of the presumptive duration, rounded down to the nearest half month, or 15% if both the current offense and the custody offense are sex offenses ranked at H or greater. So that's all sex offenses other than predatory offender registration offenses. So this would change what constitutes custody status. Right now, probation for a misdemeanor or a non-traffic gross misdemeanor or a DWI-related gross misdemeanor counts as custody status for purposes of the custody status point. This rule, those would not count. Those would not trigger this enhancement. And there would be no waiver that would apply like the current waiver rule. With respect to the impact for B2, we are estimating that there would be a 198 bed reduction. So there would be some longer prison sentences as a result of this, but those would be offset by the shorter prison sentences. The only thing I'd like to say about the text of all this is we did do some reorganization of how modifiers work. We did that for both C and D. I'm sorry, for both C2 and C3. It seems like there's some clarity that could apply to modifiers as far as how exactly the order is supposed to work, and just basically making it briefer. And so we did that for this. Let's see. Trying to move to 4D, which is the evaluation. Instead, I X'd out of it. So let's get it up again. Oh, yeah, I talked about the impact. So the pros of B2, it does provide additional punishment for committing an offense while in custody status, but at a reduced level, which you know, I think that harkens to something Professor Frey said, where, you know, if you are going to have custody status, it should be reduced in criminal history generally and devalued below the criminal history of the offense itself. So unlike the current policy, and we saw that a significant percentage of people in the history category of those three grid zones, a significant percentage, like in the low 20s, I think in each grid, significant percentage of people in the history category were there because of custody status. Under this policy, that's not going to happen. Nobody's going to be pushed across the disposition line because of the fact of custody status. The increase is only a durational increase. It still adds an additional consequence for sex offenses, for repeat sex offenses, which is in the tradition of the sentencing guidelines, or at least in the recent tradition. There's proportionality. Where the current offense is more severe, there's going to be a proportional response because it's a percentage increase. And again, like repealing it puts more emphasis on the severity of the offense and the criminal history score itself, rather than the fact of custody status. The cons are, again, there may be a perception that this doesn't adequately address blameworthiness for somebody who commits an offense while in custody status. And it could go farther in increasing repeat sex offenders. It's certainly less severe, particularly for that 2-point enhancement. That's a pretty significant enhancement, and this is the 15% increase is a lot lower than that. So that's, I guess that concludes my walkthrough of B2.
All right, comments on this proposal? Commissioner Larkin?
Thank you, Madam Chair. I think this proposal, again, was an idea I originally had. And I like the concept of an enhancement based on a percentage increase rather than imposing the custody consequence through the use of criminal history score. But when I stared this down, my problem is I don't think the 10% enhancement goes far enough. Because remember, I went through this at the last meeting. If you actually calculate, okay, what does a 10% enhancement look as opposed to going up to the next box? And you would see that most people are going to get reduced presumptive sentences if they get a 10% enhancement instead of the custody point. And as Nate has pointed out, lots of people are going to end up, you know, going from a box that would put them in prison to a box that won't put them in prison. So that again is a sentence reduction. And this result was most pronounced regrettably on the sex offender grids. On that grid, the 10% proposal results in a reduced presumptive sentence for every offender except those at severity level F with a criminal history score of 5 and those at severity level A with a criminal history score of 1 or 2. So in other words, for the most serious offenses, offenders with a higher criminal history score end up with a reduced presumptive sentence, and offenders with a lower criminal history score end up with an increased presumptive sentence. And the 15% proposal for repeat sex offenders results in a reduced presumptive sentence for every offender except those at level F with a criminal history score of 5. So while in theory I like this concept, the numbers we picked, 10% and 15%, just result in too many reduced sentences for my comfort level. So I would speak against this proposal in its current form. I mean, perhaps there is a different number that could be used that would not result in so many sentence reductions across the board. But as it stands now, that's what we would be recommending to the legislature. And I just need to I think we need to be sure we understand what we're recommending with this proposal, which would be probably a reduction in about 90% of the cases.
Okay, other comments? All right, seeing that, I'll make mine. What I like about this proposal is I think about when Professor Fraze was here and he was talking about, if you're thinking about custody status, if you decide that custody status is something that should be part of the guidelines, then the next question is, well, how much? And I think that this sort of puts a quantity to that in a different way. So it sort of allows for that increased punishment, but not within the context of criminal history. So I kind of like it in that regard. The other thing that I was drawn to about it when Commissioner Larkin proposed it originally was that it really emphasizes the severity of the offense. And I think that the guidelines were always built on the idea that the severity of the offense was supposed to be the paramount axis. And what's happened over time is the criminal history score has taken over and is having more of an effect on sentences than I think that we originally envisioned that they would. So I do like that it sort of reorients us back to the severity of the severity of the offense in that way. The downside for me is, again, because most people are sentenced, are actually received a stayed sentence. It actually doesn't get applied uniformly, and it really, it's the same problem that with all the other proposals in my mind, is that it ends up just only being applied to the people who actually go to prison. There's things about it I really like, and then that's just the downside for me. Other comments? Commissioner Larkin.
building on something you just said, you know, about this concern that there's a distinction that people that get probation don't get revoked, don't get the custody consequence, so it's not uniform. Now, this is just another idea, which you don't want to hear at this late stage of the game, but you know, what if the custody consequence was a local jail time consequence so that everybody got it? And I mean, I'm just throwing that out there because I hear what you're saying. But that would be a way to say, okay, well, if people are supposed to get another, you know, 30 days because they were on custody status, maybe you just say they have to have that as a condition of their probation if they're not going to prison and going to get it there. It's just a thought. Just trying to correct a problem with this approach, since this approach does have some appeal to me as well.
Yeah, I think that it's an interesting idea. What I would say is that I think the individual's already going to get that 30 days if they're on probation. If they remain on probation, they're already going to get that 30-day consequence for the violation of having committed a new crime. If not, they're going to be revoked, and then they're already getting a consequence that way. So I'm not sure if that solves the problem in my mind.
But maybe what you just said indicates there isn't a problem.
No, I mean, they're getting the 30 days as a consequence on the probation violation is what I'm saying. So I think they're already getting the additional punishment, and it's not necessary for us to add something to it.
Well, I would like to say something on that point, because we're talking about double counting and the person's getting the additional punishment because they were on probation when they committed a new offense. It's not an additional punishment. I mean, in my mind, when someone's put on probation and jail time has stayed and some of it gets revoked, it's not getting revoked as punishment for the new offense. It's getting revoked because you didn't remain law abiding. So I don't think it's fair to say if somebody, you know, is on probation, gets a new crime, ends up getting some of their probation revoked, they shouldn't also have a custody consequence on the new crime because they're getting it on the revo. I mean, the consequence that comes from the revo is for the failure to remain law abiding. That's the sentence that's already been imposed. That's the time they're supposed to serve and are only not serving because they're on probation. So I just have a hard time with this double counting argument.
Commissioner Knudsen.
Thank you, Madam Chair. On that same point, they're not getting consequences. So, I mean, I would agree with Judge Larkin that, first of all, it's for two separate offenses, and it's because they failed in that to follow the rules of probation and comply with the sentence. So, but more importantly, they're not getting an additional sentence. It's being served concurrently and whatever the highest sentence is. And so to say that all of these people are getting double sentences or they're already getting punished, they're not. It's subsumed in the new sentence on the new offense for the most part. That's my experience.
Was any other comments there? Okay. I was just I'm just thinking through, I mean, I've just recently done research on probation violations in Ramsey County, and you know, what we found there was that on these felony offenses, if somebody had a violation, the most common consequence sort of flowing from that violation was some sort of local jail time. It was very rare that individuals in that context, in the context of our study, were revoked to prison. So they were receiving local jail time as the consequence. And, you know, the instances of, you know, it's not fair to say that, like, if somebody received a new felony, if they're on probation for a felony, if they committed a new crime, it wasn't necessarily a new felony, you know, so sometimes it was a lower level crime, and that would be the reason they weren't revoked. because it wouldn't be a crime that would necessarily send them to prison. So they were receiving some sort of local jail time. So I mean, I think there's a variety of outcomes that could flow from a probation violation. That's the only point I'm trying to make. And I guess my point of view is just that we should deal with those two things separately. That, you know, prosecute for the new crime. If they've committed a new crime, prosecute that crime. If that's also a violation of probation, deal with that separately. But I'm just saying that those are the places that it feels appropriate to deal with that behavior rather than here in the guidelines, from my perspective. Any other comments? Okay, let's move on to B3 then. One cell discretionary enhancement.
Thank you, Madam Chair. So Justice Moore just talked about the waiver when we were talking about the last policy. This is, I think of this as sort of the opposite of a waiver. So it's like a waiver, it's discretionary with the court. But instead of opting out of the custody status point, this is opting in to essentially a one cell increase in the punishment. So this is like B2. B3 is a sentence modifier. At least that's how we've drafted it, as a sentence modifier, and it modifies, but it's actually kind of a different sort of modifier. It's the way we've written it. It's to be done at the very beginning before you apply any other modifiers, essentially. So it's like it changes the presumptive sentence first, and it changes it to increase it by one cell on the grid. So that could include a dispositional change if moving one cell to the right means you're crossing the dispositional line. So it's essentially like getting an additional criminal history point, but it's conditioned. It doesn't apply unless the judge makes a finding that the presumptive sentence does not adequately address the need for punishment in the particular case. And then it does apply. So if and only if the judge makes the finding, then the presumptive sentence is increased. So that's the mechanics of this. And that is important for something that we'll be discussing later, exactly what the mechanics are. So in making the determination of whether, so this, sort of a preview on B4, this is different from B4 in that this gives the judge some, admittedly very broad criteria, but some criteria on whether to make that determination on whether the presumptive sentence does or does not adequately address the need for punishment in a particular case. We're saying that the judge must consider the extent to which the custody status relates to the defendant's culpability or amenability to probation, and the extent to which sanctions available to the state for violating the requirements of the custody status would adequately address the need for additional punishment. So this is introducing into the guidelines a new concept of looking at, in a custody status case, what are the state's options as far as extended incarceration or probation revocation or segregated confinement, or any of the options that the state. I'm hard pressed to think of a custody status type where the state does not have some sort of an option like that. I guess it would be if somebody's in segregation in prison already, there's really not much else the state can do. But other than that, it seems like there's always some option, and the court here can consider that in determining whether the presumptive sentence adequately addresses the need for punishment. Actually must consider that, and must consider the defendant's culpability or amenability to probation and how the custody status affects that. And I would like to just talk about the text. So I'm going to jump to 4C here and talk about the text because how we've written it here particularly says that so the criteria are that under the particular circumstances of the custody status, the presumptive sentence does not adequately address the need for the punishment of the current offense. So you're looking at the current offense's punishment, but you're looking at the particular circumstances of the custody status. So it's the particular circumstances of the custody status and how that relates to the punishment of the current offense. So I just point that out because it's interesting wording, and it's something that the commission may like or may not like if this is a proposal that goes forward. So let's look at the impact of B3. This B3 and B4 really presented some challenges for staff as far as estimating the impact, because both involve a very broad amount of discretion to the court. Now, B3 on its face is not discretionary. The court must increase the sentence one cell, essentially, if this is found. But given the nature of the findings, it gives the judge a lot of latitude in making the determination about whether or not the presumptive sentence adequately addresses the need for punishment in the particular case, right? So given that, we really don't know how often this is going to be applied. We assumed, and this may be an incorrect assumption, but we assumed that Blakely would not apply, which is different from B4. I am not expressing any legal opinion on whether Blakely would apply, but we assumed that it wouldn't because it's a change to the presumptive. And for those who aren't aware of what I'm talking about, Blakely is the rule that applies to the Minnesota sentencing guidelines that says that anything that increases the sentence beyond the presumptive sentence has to either be admitted by the defendant, or it has to be a prior conviction, or it has to be found by a jury. And in this case, we would suggest that perhaps Blakely wouldn't apply because this isn't an increase beyond the presumptive sentence. This is a change to the presumptive sentence. And so perhaps Blakely doesn't apply. Again, I'm not here to express an opinion that, or argue that that's true. I'm just telling you what we assumed as staff, and that the quality of our assumption corresponds to the quality of the quality of that legal opinion, which I'm just saying I don't really know. So we assumed that judges would find that this enhancement applies in 50 to 75% of the cases with a custody status point. If that's an overestimate, then our estimate of the prison bed impact is wrong. So basically, we took B1's estimate and we took a fraction of that. So in this case, we took 25 to 50% of B1's estimate, which is 134 to 268 prison beds, and we assumed that it would apply somewhere in there. So if the judge is going to find that the enhancement applies in fewer cases, then the prison bed impact, the prison bed reduction is going to be higher than that. So really, it's sort of, your guess is as good as mine as far as that goes, or probably much better than mine, as to how often judges are going to apply this particular enhancement. So 268 is that middle number. So I already talked about the text. So moving on to the pros and cons of B3. So pros, it allows for individualized application of the enhancement. It's only when it's necessary to address the person's blameworthiness. So it lets the judge look into, sort of assess the sentence and see whether it is an appropriate sentence. It, like I said, is unique in that it permits recognition of other sanctions that may be available to adequately address this situation. The current structure is sort of blind to that. blind to whether or not there's whether or not there's some other punishment that's possible. I suppose in consecutive sentencing, there could be some consideration of that. But otherwise, it's not overtly stated in the sentencing guidelines. And it's also limited. So it's limited to one cell. The cons, obviously, uniformity is a very important guidelines principle. It's arguably why the guidelines were created. And this tends toward lack of uniformity, kind of like the waiver, which also tends toward lack of uniformity. So it's really a trade-off between looking at the individual case versus uniformity. And it does raise Blakely concerns. There's some question as to whether the court could raise this on its own or whether there would have to be some kind of a jury finding of blameworthiness, which is, that's going to be really difficult if that's how it ends up happening. And there could be litigation that corresponds to that. So that's the end of my walkthrough of B3, Madam Chair.
Can't hear.
Madam Chair, we can't hear you.
I'm sorry. I apologize. You'd think I'd figured that out after 3 hours. Commissioner Ladd and then Commissioner Middlebrook.
Thank you, Madam Chair. I will just say a couple of things, and I don't mean this to disparage any judges across the state, but I would just say this seems to be an area where we would have a lot of disparity in sentencing, and that similarly situated people would not be treated alike. I feel like I'm all about discretion with the trial court, but it seems to be pretty open-ended, and I have some concerns about that. When I first read through this and had to read through it a couple of times, to me it seemed like a sidestep to the departure process, in that we're using different language, but the very findings that the court needs to make for aggravating or mitigating factors under the guidelines for departure are kind of baked into this process as well. And while I'm not, I don't speak for all 87 county attorneys in the state of Minnesota, I can say that I look at this as a Blakely issue, and I would be quite surprised if Commissioner Middlebrook and her crew wouldn't file some paperwork on this and put us to task on this. So I do think that there are some Blakely concerns here. I think there's a lot of disparity in terms of how this would be played out across the state. And again, I think this brings, in my mind, some conflict to the departure process that is established and requires a variety of things for the practitioners in the court to go through to apply an enhanced or a mitigated sentence in the first place. So I struggle with this one for that reason.
Okay, Commissioner Middlebrook.
Thank you, Madam Chair. One of the things with this proposal was to try to address the concern that the 10% and 15% from B2 wasn't going to be sufficient. And I recognize that there's a question on the Blakely. I recognize that. It seemed like it was one of the things where this allowed for the individualized application of the enhancement, whereas B2 was not. There's no discretion involved. I don't know, and perhaps as Director Wright said, that it's sort of the opposite of the waiver. So it certainly could be revised so that it would not be discretionary, but to include the waiver provision. It seemed like that was one of the big concerns with the 10% enhancement, where it seems an enhancement fits better on custody status where it should be applied.
Okay, any other comments? Commissioner Larkin.
I think if it's not mandatory, this is going to be a Blakely issue. I just don't know how you're going to get around that. It's one thing to say we're going to waive something. It's another to say a judge is going to have discretion to bump you up to the next box and then with a straight face say, well, that's not a departure.
Okay, any other comments? All right, hearing none, I think we could move on to B4.
All right, it takes so long every time, Madam Chair. For some reason, the button that allows me to share is always off the screen.
I think
So-
you're doing a great job, actually.
Oh, thanks, Madam
Thank
Chair.
you.
So B3 is, B4 is sort of similar to B3, but it's, instead of being a sentence modifier, this is an aggravating factor. So it's a little more familiar ground, I think, because we know what to do with aggravating factors. But this is a unique aggravating factor because unlike most aggravating factors, unlike all aggravating factors, this aggravating factor is written in such a way that its effect is intended to be limited to increasing. And I should have said on the last one that also had the sort of preserve the 2-point rule. You know, I said it moves over 1 cell to the right. It moves over 2 cells to the right if it's a repeat sex offense. This also has the same thing. So essentially, this aggravating factor can support a criminal history. This aggravating factor can support a sentence that is found in the cell 1 cell to the right or 2 cells to the right in the case of a repeat sex offense. And unlike the previous, unlike B3, there aren't any criteria here to guide the judge's discretion here. It's simply an aggravating factor that the judge may but is not required to depart from the sentencing guidelines if the crime was committed while in custody status. Let's see, so the impact here, again, this is really in the category of your guess is as good as ours. We assume that the aggravating factor will be used in no more than 25% of the cases, which means that the impact will be no less than 75% of the impact of B1. So the impact of this would be no less than 402 prison beds, and possibly as many as 536 prison beds that we found in B1. So the reason why we used such a lower number is because our experience has taught us that aggravated departures went down significantly when the Blakely and Shattuck cases came out. That extra impediment of having a jury make the required findings was very difficult. Now in this case, the finding will be pretty straightforward. It will be whether or not the defendant was on custody status. So you know that if you already have a jury impaneled, it might not be too much of a trick to ask the jury to stick around a few minutes after the verdict, have a probation officer or a jailer come up and say what the defendant's status was on the date of the offense, and or if the offense was committed in jail, they might already know what the custody status was. So maybe it could be a jury interrogatory. So this might be significantly easier than a lot of Blakely cases, but so that's, I think, why it goes as high as 25%, but I don't think it's going to go much beyond 25%. So we would assume an eventual reduction of at least 402 prison beds as a result of this. I think I've already explained pretty much what the text is. It's a pretty straightforward textual change. And then as far as the pros and cons, similar pros and cons. It allows for an individualized application of the enhancement. Presumably the judge, although there aren't any guiding factors in the guidelines, presumably the judge would only use it when it was necessary to address the person's blameworthiness. we already have a system for departure, so it fits within that scheme. It does place a limitation on the degree of enhancement, and it simplifies the guidelines in the sense that we are removing 2B2, so I mean, I guess that's true of all the B series, but it simplifies the guidelines. The cons, like B3, it wouldn't be uniform in application, and it will require the Blakely process. So this could be considered onerous by practitioners, but you know, I guess if the prosecutor really wants it, it wouldn't be too hard to prove it. So I guess that's a mitigation of that particular con. So that concludes my walkthrough of B4, Madam Chair.
Thank you. Any comments on this proposal? Commissioner Larkin?
Thank you, Madam Chair. My first question is this a person characteristic or an offense characteristic? Because the law is pretty clear that dispositional departures must be based on person characteristics and durational departures must be based on the offense characteristics. Now, this proposal seems to result in both durational departures and dispositional departures, depending on which box you start with. So that might be something that interjects confusion into the law. And I do think it's, you know, obviously more work. We don't now have to have a jury find that a person's on custody status to impose a custody consequence. So that's problematic. And lastly, I'd say if we were going to do this, I don't understand why we just wouldn't say custody status is an aggravated factor and not tie it to a 1 cell increase, just have it be a permissible departure factor, and then the judge can depart anywhere up to the statutory maximum. But you'd still have the issue of, is it a person characteristic or an offense characteristic or both? It sort of seems like both, and I'm not aware of any characteristics where we've said, yeah, it's both. It's usually one or the other. So I'm just thinking of what the legal issues are going to be if we did something like this. And I could tell you that the judges aren't going to want to do this because they're not going to want to have to Blakely trial on custody status when they didn't have to do that before. Or the prosecutors, for that matter.
Okay, other comments on this one?
Madam Chair.
Commissioner Estrada.
What I appreciate about this proposal is that it does give the discretion to give essentially the custody status point. I think that's one of the reasons why it's a 1 cell aggravated factor, is because a custody status point is really just 1 cell. So it's like what we have or what we had previously. And I think it addresses the concern of really giving it to the people who need it, right? I think I heard multiple people say that, you know, they can agree that for drug offenders and theft offenders and people with some of those low level crimes that may be suffering from addiction and things of that sort, we can see how it's beneficial. But for people that, you know, that need to be in prison or that need to have this custody status point, or there is that blameworthiness, there's that opportunity for it. I don't think we should ever be making decisions based on whether something's going to be more work or not, or if we have those resources or not. It is a factor, it is going to be difficult, but I don't think that that's what should be driving our policies and our procedures for something that impacts so many people's lives. So that is something that I appreciate about this proposal, is that it does, you know, allow for that discretion and that proof for the people who are, you know, have those more serious offenses.
Other comments? So I'll make mine. I had a similar perspective. Well, actually, my perspective is a blend of both of the comments that were just made. Because I like, what I like about this is the individualized consideration. It's kind of the opposite of what Commissioner Moore was saying earlier. You know, he liked the ability to have the waiver to take the custody status off of particular people to whom it didn't apply. This is sort of the inverse of that, saying, well, no, let's put the work on adding custody status to the cases where it should apply. So I do like that individualized approach. Like the more I think about it, the more I, and I also appreciate that the one cell, proviso here is an attempt to limit the degree to which the departure could be made for this particular reason. But I'm struggling with how to make that work. Because it just dawned on me, as I was reading this again, I was just a description. So honestly, I'd have to look again at how the language was written on this one. But I was thinking, what if it's two cells on the grid that are stayed cells? So you're in the stayed zone of the grid, and you're, lower end towards the left. There's two cells next to each other that are stayed. So does that mean that the only option the judge would have would be to increase the duration if they're doing this departure, or would the judge also have the ability to do an aggravated disposition? I think the way this is reading, the answer would be no, because that's not in the cell next to him. But you tell me what you're thinking.
Madam Chair, that's how I understood the proposal, and that's how I wrote it up.
Okay. So that's just a unique limitation. We've never made a limitation like that, and it's something we have to think through. Is it workable? I mean, we do. I hear Judge Larkin on the confusion between, is this a person characteristic or an offense characteristic? We already blew through that wall with the probation departure change last year. So I think that we've already opened the door for those types of considerations to happen both ways, kind of going forward. I'm not as concerned about that change, about that potential change, but just trying to figure out what would the sentence be, what sentence would be available to the judge who is making this departure. I think I'd want to think that through a little bit more to be more clear on that. Any other comments or questions? Commissioner Middlebrook.
Thank you, Madam Chair. I guess I was just going to try to answer your question about if they're in the stayed, if there's a limit to one cell and that's still in the stayed zone, it seems that it would just be an increase on the amount of the length of the sentence that's stayed. One of the things with this proposal, I thought it also does the individualized looking at who deserves to get the additional punishment. It looks at, are there these individuals that are more blameworthy that should get the additional consequence? And it seemed that this would take care of, that. And honestly, I see all the time that where there's some factors that the defendant will waive the Blakely trial and just let the court decide. They do it all the time on whether, on prior convictions, and a lot of different elements that they will just waive the Blakely trial on. So I would echo what Commissioner Estrada said, that I don't think that, anticipating a lot more litigation, Blakely trials, I just don't see that given what I see coming through where the defendants let the court decide this issue.
Thank you. And so let me think this out a little bit more given the answer that you just gave, Commissioner Middlebrook. So the other potential here that this could allow is if a judge is considering an aggravated departure based on custody status, and we're now on the straddle cell, we're on the cell where on one side it's a state sentence, on the other side it's a prison sentence, they'd have to take into account sort of whether that disposition is appropriate given the facts of the custody status too, right? I mean, I would assume that, I guess the question would be like, do they have to go to that disposition and duration, or could they sort of pick and choose what kind of departure they're going to make? Commissioner Middlebrook.
Thank you, Madam Chair. I would say that it would be much like what Commissioner Larkin has talked about, where if someone is not amenable because they're on a custody status and commit another crime, particularly some of the more serious crimes, and the concern is that they would not go to prison, that they would stay in the probationary sentence. That would give that departure reason would allow the judge to do that if it fit the case. So I thought that seems that would take care of that concern.
That's actually sort of requiring more consideration of that decision. I'm thinking out loud here. I'm just thank you for indulging me. Okay. All right, any other comments? Okay, so at the end of all the A's, I gave you a chance. Like, was there anything else that you thought of along the way that you wanted to make sure that we all thought of? So now we're at the end of all the B options. Is there, anything else that people have thought of along the way that they didn't get a chance to voice when we were back in the proposal that they want to make sure that we're all thinking about? Nope. Okay. All right. So we have gotten through the proposals, and I want to thank the commission for a very good discussion. I think that we've done a lot of work to put on the table sort of what the ups and downs are of the different proposals. And I mean, I certainly, certainly things have been said today that I hadn't thought of before, and I really appreciate that input. What I want to do though is we are at 7 proposals. If we're going to solve it this year, we need to be able to vote on a proposal next month. And so what I'd really like us to do is see if there is anywhere that we kind of collectively think we could lop off a couple of proposals. If we sort of all think about which proposals after talking about them today are we still interested in, are there any that we're not so interested in sort of collectively? And so Nate has sort of devised and helped us come up with a way to try to get to that point collectively. For those of you who have been on the commission longer, I once made us all put dots on a board. We're going to do the electronic version of that today, and I'm going to hand it over to Nate to talk about how we're going to do that.
All right. Thank you, Madam Chair. So this is basically the chair's looking for guidance on the November agenda, because just to remind everybody of the timeline here, if the commission wishes to make a change effective in 2022, it has to submit it to the legislature by January 15th, and that means it has to go to a public hearing in December, which means the commission has to make a decision at the next meeting. So to guide the chair in the input, we've got a question for you. I'm going to show that out here. This is kind of the virtual dot version. Share my screen. Okay. So what I would like to do is send you each a link by email so you could answer this question. And it's on a scale of 1 to 5. How interested are you in continuing discussions about each proposal? So this is what this is going to be able to do is in a pretty quick order give us a sense of how much, whether you like a proposal or not, how much you like a proposal. If you want to kill the proposal, you leave it at the 0 or at the 1 on the left. And if you really like a proposal, you can move the slider over to the right. So it's a sliding scale for all 7 proposals. And then once you're done, you can just submit it. And what we'll get to do is see how everybody likes these proposals at the end. So it's really a nice way of without getting you to commit to anything, just getting a sense of how much you like each of these proposals, and then we'll be able to share it altogether. In fact, I could share it as you're providing your input, but I think it's probably better not to do that so you don't get influenced by other people's choices. So any questions about how this is going to go? In a minute, my intent is to send out one email to all 10 of you with the link for you to provide your input. Any questions on that?
Madam Chair, I have
Does
a
anyone
question.
have a question? Commissioner Larkin?
So when you say you're going to share our responses, so each person's response is going to be shared individually?
Madam
No.
Chair, I don't have the ability to do that. I'm basically sending out one link to all of you, and by
My concern, Madam Chair, is that this is an open meeting, and I wonder if you're going to ask us to do that sort of rank voting and the individual choices are not available to the public. Are we violating the open meeting law by having secret voting, even if it's a straw vote?
It's not a vote. So I mean, we did this before with the agenda where we just put dots to indicate interest. So I'm just looking for some input for the agenda. Do we want to put all 7 items on the agenda for next time, or do we have more interest in just 5 of those items? So basically, we're going to do this piece, and then we're going to see what those results are. If there's a couple that are on the lower end of interest, then we would have a discussion as a commission as to whether we should include those on the agenda next time or not.
Yeah. I mean, if I may, Madam Chair, so I think of this as basically advice to the chair. It's not making a decision. The decision is the vote
Okay.
you have at the November meeting on setting the agenda. If there's something missing from the agenda, at that point, you can ask to add it to the agenda, but I don't know. But that's my thought.
Okay, so what you're saying is, regardless of what these rankings are, they're not necessarily dispositive. So it's not a vote in that sense.
Yes, that's correct.
Okay, that's better.
All right, so I'm sending the link now.
Oh, Commissioner Knudsen.
Oh, I'm sorry. I
Oh,
just
but
sent the
Madam
link,
Chair, you're
Madam Chair,
saying
just
that-
to be clear.
You're saying that this vote, though, will determine the agenda for next time.
No, this is going to give us a direction to talk about. So we're going to do this now, and then we're going to talk about the results. So Nate's going to put them up so that you'll be able to see them, and then we will talk about as a commission. So would we like to keep everything on the agenda next time? Or given that there's if we see that there are patterns where there's less interest, is there interest in maybe dropping a few items from the agenda next time?
All right, thank you.
All right, so I
So
guess, Madam Chair, at
should
this
go to
point,
our
I'd like to
email
know
now.
if anybody's not getting the email, they should have the email. The link should be live. It should work. If anybody has any questions about the link or how it works or hasn't got the email, I'd appreciate knowing that. Otherwise,
Madam Chair, I got notice that this website doesn't work in Internet Explorer.
Do you have another? Do you have
Yeah.
like a?
Let me try.
Another-
Let me try Chrome. See if it works.
Maybe you can cut and paste the link into another browser. Are you, what's it looking like in terms of the number of people who participated?
80%.
Okay. That's what I sort of figured.
Sorry, I was typing and I wasn't muted. My apologies.
Oh, no problem. All right, so just for the benefit of all commission members, in case someone had to step away for a moment, I just wanted to reiterate that Nate has sent a link to all the members for so that you can express interest in continuing to discuss the proposals that we heard today. So we're hoping that everyone will complete that, and then we can take a look at the results pretty quickly here.
So Madam Chair, I'm detecting that 10 people have responded. So hopefully that means all commission members have responded. If anybody's operating under a different understanding, then please let me know. Otherwise, I'm going to close the questionnaire.
Great.
Okay. So, and I think I'm going to present this now, but the results are going to be in the minutes.
Oh, it went away. Oh, I see.
What's that? Oh, I'm just trying to share my
Yep,
screen.
got it.
All right. So
I feel like there should be a drum roll.
Yeah. So what this does, it shows you the average score, but it also I just want to highlight, I thought this was some kind of decoration here, but the waves in the background are how people actually responded individually. So on this one, you can see there's kind of I'm just starting with A1. It had an average of 2, but 4 were 1 and 4 were 3, and only 2 were actually 2. And you can see that on each one so some of them have valley in the middle. So A2 is a good example of that. And that's to show that there was some differences of opinion there on that. So you got 4 commission members who were not interested in a score of 1 for displaying half points on the grid, and 4 commissioners were very interested, and 2 commission members were only interested on a level of 2 for that. And I could show that for each one. For A3, we had 8 who were, so that didn't have a valley at all. 8 were not interested, in 2 were interested only to a point of 2. And then B1 was definitely a valley, 4 on the 1 side, 5 on the 5 side, and 1 was 4. B2 was one of the more evenly distributed ones. Starting from 1 to 5, it was 3, 2, 3, and 2 for an average score of 2.4. Then replacing with the 1 cell discretionary enhancement, B3 was 5, 3, 2, 0, and 0. So an average score of 1.7. Then replacing with a 1 cell aggravating factor, which actually had the highest average score, had 5 people very interested, 2 not at all, not interested, and 1 voting 1, or one with a 1 response, 1 with a 2 response, and 0 with a 4 response. So does that give you the information you were looking for, Madam Chair?
Yeah, let's leave it up while we have a discussion.
Okay.
So thank you. So I'd say that, the one place that seems like maybe there's no further interest in discussing. The option is the quarter point option. Do folks sort of agree with that? I mean, is that one place that we could potentially narrow the field for November? Commissioner Knudsen.
Yes, I think so, but with the caveat, as Madam Chair, you mentioned the discussion of the units and points for misdemeanors. To incorporate whatever we do to unify that description of units and points on misdemeanors.
Oh, you like that idea and you want to sort of carry that forward is what you're saying?
Yep, yep.
And then, you know, I'm not seeing much else that could easily be dropped. I'm just wondering what are others' impressions here? Because like the two that have the valleys are A2, display half points on the grid. B1 has the valley, repeal without replacement, and then B4 also seems to have. Well, no, that'd be okay. So B, display half points and repeal without replacement. Since they have the valleys, it seems like there's enough commission members that are interested in both of those proposals that we need to continue talking about both of those. So I don't see I think those need to stay. And then the rest of them are so, sort of in the middle that it feels like there's enough sort of interest along the way that, maybe we can't knock it off, but potentially B3 replaced with a one cell discretionary enhancement has maybe a little bit less of a spread there. So Commissioner Moore.
Yeah, I was going to suggest we drop B3. That seems 1.7. That seems like it's significantly less than. It seems like there are others that are maybe more worthy of our time.
More worthy of our time. What do others think about that, Commissioner Larkin? Oh, if you're talking, I think you might be on mute.
I'm sorry, I'm just going to be a realist here, having been through this before in terms of the timing. It's my understanding that we need to vote on a final proposal in November and take it to a public hearing in December.
Yep.
Realistically, I don't see how we can do that if we go forward with any more than 2 proposals. So I think what we should do is take the 2 with the valleys, the displaying the half point on grids, which is sort of like, well, no real change, or the least amount of change, I guess, I don't know. And then just doing away with custody status points altogether. I simply don't think we have the time or ability to work through anything else at the next meeting. I mean, they're good ideas, but if we have to do something in November, I think we need to really narrow it down to 2.
It seems like, I think that's interesting, honestly, but it seems like B4, the one cell aggravating factor, also has a fair bit of support, and that one's higher. So I'm wondering if we should be thinking about the 2 with the valleys plus B4.
Madam Chair, I just point out, those were the only 3 that actually got any 5s.
Mm-hmm. Yeah, true. Did you want to say something, Commissioner Moore? Sorry.
Yeah, I would support that, Madam Chair. I understand what Judge Larkin's saying. I think she's right that we need to narrow this down, but it seems like it'd be difficult to throw out the one that's got the highest interim score right now from the discussion, and maybe could provide a middle ground.
That's a good point. It is sort of a middle ground. Commissioner Ladd, do you have your hand up?
Yes, I do. Thank you, Madam Chair. I think I agree with Judge Larkin just in terms of what we've even just done here today, and I don't think we got down into the weeds. I mean, we raised some issues and we pointed out some highlights of each one of these, but to really sort of have a meeting next month to sort of go over all these minus one of them, I don't know how we're further along. And I also think that if that was going to be the intention, that we were only going to do, you know, pick 2 or 3 things, and we should have just voted only on 2 or 3 things. I wouldn't have voted on all the ones that were presented, and that would have maybe flushed it out a little bit clearer for the chair. But I would agree that the 3 that have been suggested make some sense to go forward, because I just don't know how we're going to get it done otherwise.
So you're saying, so take the 2 with the state. So, all right. So I'm hearing from two spots or 2 places here that we would be looking at A2, display half points on the grid, B1, repeal without replacement, and B4, replace with a 1 cell aggravating factor as the sort of slate of 3 options that we would consider in much more depth in November. Is that acceptable to everyone? I'm seeing thumbs up. I'm seeing head nods.
Yes.
I think that's an amazing step forward for this meeting. Okay, let's do it. That'll be our agenda for November. So please do look at the language of those 3 proposals. If you see anything, I think it would be helpful if staff had input ahead of time, if there's any changes that need to be made to that. Commissioner Larkin.
Can you give us a preview of what the process will look like? I mean, can we at least come to that meeting, discuss the substantive policies, agree on it before we turn to the language? I mean, I really don't want to be having discussions deep in the weeds about the language for all 3 policies. I would much rather say, okay, what is the majority's choice on the particular rule, and then focus in on that language, because our time is going to be really limited.
Mm-hmm. No, I think that makes sense as a method. The one thing that we didn't do today is we didn't talk about, you know, this policy versus that policy. So I would imagine that, you know, a lot of our discussion would be sort of
Compare and contrast.
Compare and contrast next time around. Yeah. So I think you're right. We have that discussion first. We could have a vote on which policy it is, and then we can take a closer look at the language that day. I think that, you know, we'll want to do a good job on the language that we have before us, but, you know, the good news there is that we also have additional time to fix that, because it'll go to public hearing. We'll also get feedback. Other people will probably identify things in the language that we missed. And then, so we'll have another opportunity to maybe hear that input in December, and then really get it refined in January, if necessary. Commissioner, or not Commissioner, you should be a Commissioner. Director Wrights.
Thank you, Madam Chair. So in addition to any feedback you might have on the language, if you have any feedback on the assumptions that we're using in our impact estimates, I'm particularly thinking of the aggravating factor. I mean, we picked 25%. If you think that's high or low, I'd love to hear from you. I don't really have a good basis for making that judgment. So if you think you have an opinion for me, I'd be welcome to hear it. But I guess the flip side is, you know, you can sort of adjust it in your own mind, because it's just 25% of B1. So thank you, Madam Chair.
All right, any other comments before we close this item out? All right, Nate gets to do his executive director's report.
Yes, Madam Chair. So really, I think we're still in our hiring search. Honestly, it's been we've been battling to devote enough time to it with all the stuff we've had elsewhere going on, but we hope to have some good news by the next meeting. That's point number 1. Point number 2 is based on your feedback at the last meeting, we do have some meetings. I think Jill posted 2 meetings on our YouTube channel, so you are on YouTube. Congratulations. And I think that's all I have, Madam Chair. That concludes my report.
All right, great. Thank you. We do have to allow for public comment, so let's go ahead and
Madam
open that
Chair?
up. I understand. Do you have to leave, Commissioner Larkin?
No, I have a question for Nate about his report.
Oh, I'm sorry. Go ahead.
What's the status of our vacancy, our victim representative?
Madam Chair, that is an excellent question, and I normally would put that on my report. I have not contacted the governor's office. I've just been kind of slammed lately. So I'll definitely have an update for you on that if the governor has not appointed somebody by the November meeting. And I apologize, Madam Chair, for not having that in my report today.
I think it's important that if we're going to vote on this change, which could be a major change, that we have the victim representative at the table, at least for the vote, even though he or she will be coming to the table late.
I'm on vacation tomorrow, but I will send an email to the governor's office tonight.
All right. Anything else for Nate? Any other questions? Okay. Public comment, so if anyone has to drop off, I completely understand that. We did run over, but in the meantime, the last item on the agenda is to allow for public comment. So I want to open that up now. There's no one in the room here at the Capitol, so this would be anyone online.
Sure, I'm missing the participants panel. It's wrong. Can anybody see who the two attendees are? I'm supposed to. Okay.
Alicia Newman and Kevin Featherly.
Thank you. I'm having.
So I'll let you know that Alicia Newman is my intern this semester, so I doubt that she wants to speak. I don't want to speak for her though, but that would be my guess.
Okay, so yeah, I'm trying to click on participants and get it to pop up. Hey. Okay, please bear with me, Madam Chair. It's not letting me display the list of participants.
Please scroll down to the bottom. Do you have a view all attendees piece that would make it? Oh.
Hasn't ever done this. To expand. Oh, there it is. Okay, it was not expanded. Okay, thank you, Madam Chair. Sorry about that. All right. Members of the public listening remotely, in a moment, your microphones will be unmuted. If you do not wish to make a comment, please remute your mic to reduce feedback. If you wish to make a comment, please state your name and the chair will call on you. I'm now unmuting your microphones.
To end the suspense, I have nothing. Thank you.
Thank you, Kevin.
All right. Looks like, so Madam Chair, they've all remuted.
All right. Okay, so we're good there. All right. Hey, it's only 22 minutes past the official end of this meeting. Everyone did great today. We managed time great. It was a great discussion. I'm looking forward to November. Commissioner Larkin, do you have another comment?
Just one quick question for my notes. I'm a little brain dead at this point. So the three options we're going to consider are A2, the half point grid, B1, repeal custody status point with no replacement, and B4, one cell aggravated factor.
Yep, that's right.
Perfect. Thank you.
All right.
Good meeting.
Good meeting today. I agree. Good work with the commission. Unless there's any objection, the meeting is adjourned, and I'll see you in November. All right. Thank you.
Thanks, Madam Chair.
Thank you.